Hello, Shubhi, Pratyusha, how are you?
Good
Shubhi, can you
afternoon,
hear me?
ma'am. Yes,
Good
ma'am.
afternoon. Okay, great. Good afternoon, Professor Somshekhar. How are you?
Good afternoon. How are you? I'm fine, thank you.
Yeah, great to have you in two sessions.
Yeah, thank
A
you.
lot of
Thank you.
learning.
Right.
Yeah, you're very
So,
welcome.
I'm
Thank
on
you.
time, right? It starts at 2.
Yes, you're on time. Yes, you're right.
Okay.
Shubhi, how long before we start?
Ma'am, we only have 19 participants, but if you want, we can start now, else the session will run late. So it's,
We'll start.
I mean,
We'll, we'll start on time. Participants can join.
yes, yes. And anyway, we are recording the session, so I don't think that would be a problem.
Yes. Okay. Yes. Thank
Thank
Uh,
you, sir.
just trying to understand the background of the participants to know the level at which I can uh, take this session and also the number of participants expected.
Sir, we expect some 60 participants, a total
Okay.
of 60 participants to join.
Okay.
Also, there are some people who watch us on YouTube as well, because this
Oh,
is
yeah.
being live streamed, so people watch it there as well. We have economists and we also have law graduates um, joining us, and we have a mix of students. So some are assistant professors, some are students, and some are interdisciplinary students. So it's a mixed bag, sir.
Good. Good. All right. Thank you. So I'll just get my slides ready
Yes, sir.
and we can start.
Okay, sir. Yes, sir, we see your slides. So before we begin this session, I request Pratyusha to please introduce her and then we can begin with the session. Thank you so much, sir.
Sure, thank you.
Afternoon, sorry, sir. Good afternoon, esteemed resource persons, attendees, and members of the center. Welcome to the fourth day of the GNLU workshop on research on law and economics. Without further ado, we will be beginning with the first session of the day, which will be taken by Dr. Somashekar. He is a professor of economics at the National Law School of India University and has over 20 years of experience in teaching students of economics and law. Spanning this career, he has been an advisor to the Ministry of Commerce and Industries, Government of Karnataka, to help formulate the industrial policy. A two-time United States International Visitors Leadership Program participant, a global visiting professor at the Dedman School of Law, Southern Methodist University for 5 years, and an Indian Council for Cultural Relations chair professor at Sciences Po. His publications and research reports are focused in the area of competition law, in particular, relating to e-commerce and high technology sectors and other areas of regulation. He is currently the director of the Center for Competition and Regulation, an empaneled advisor to the Competition Commission of India, and a member of the advisory board for the European Doctorate in Law and Economics. Today, he is in our presence and will be discussing mobile ecosystem and antitrust and economic analysis of crime with relation to India. Over to you, sir.
Thank you. Let me just restart the share. So thank you very much for the kind introduction. All right, so in today's topic, we will be discussing the mobile ecosystem and competition law in India. When we say mobile ecosystem, of course, what we really mean is the ecosystem that constitutes a smartphone, rather. All right. So this is a diagram which could probably well reflect um, the entire ecosystem of a smartphone. All right. So you have social network providers, you have technology providers, you have cloud services, and of course, very important app stores, analytics, and app developers, other app developers such as API and UI builders, and then of course the device manufacturers. So all of them constitute the mobile application ecosystem. Now, the question over here, or the most important uh, part of today's discussion, lies in whether this ecosystem is competitive enough, or whether uh, the ecosystem is such that it does not allow for competition, and therefore the benefits of competition, that is in terms of reasonable prices and innovation, or in other words, static and dynamic benefits, are present. So if it's not competitive, and if you have a dominant player, and if this dominant player is abusing its market presence so as to create anti-competitive effects, such as, for instance, excluding competitors or charging excessive prices, then obviously um, um, those who are part of this ecosystem, as well as the final consumers, may not really stand to benefit as much as they would have benefited in a competitive setting. Right? Okay, so a quick background as to what's been happening. A couple of years back, the European Union Competition Commission fined Alphabet Inc., or Google as we would Alphabet Inc., owns Google and is the corporate entity. So Alphabet Inc. was, fined 4.34 billion euros for abusing its dominance in its mobile operating system. All right. Now, similarly, the Competition Commission of India has also received complaints with respect to Google's potentially anti-competitive acts in the uh, mobile ecospace. Now, there have been 3 complaints, and prima facie, the CCI has decided to take up investigations with respect to them. And these investigations pertain to Google's agreements with the original equipment manufacturers of smartphones and also smart TVs. All right. So let's have a look at what the EU Competition Commission found. And then after we go through what the findings there were, we'll go on and try to see the potential outcome that can be in the case of India. And through that process, we'll just go through the methodology of operationalizing competition law in India and the kind of law and economic analysis that would come into the picture over here. All right, so over here, the relevant, uh, you know, league or regulatory framework would be the Competition Act. In the Competition Act, we would specifically focus on Section 4, which deals with abuse of dominance, right? So in Section 4 prohibits the abuse of dominance, right? And what are these kinds of acts of abuse of dominance? We will soon see. But in trying to establish abuse of dominance, there are two very important steps that are needed. Firstly, we have to establish that a firm is dominant. And secondly, we have to establish that there has been an abuse of dominance. All right. So right now, what are we doing? We are going to investigate and see if this mobile ecosystem is competitive and leads to competitive benefits, or whether it has actually been captured by one dominant firm and that dominant firm is abusing its dominance, which should therefore mean that potentially as consumers, we may not derive the best possible benefits. All right, and the other participants of the ecosystem may also not be deriving the best possible benefits. All right, so let's go to the first step. The first step is establishing dominance. All right, so if you have to establish dominance, then firstly we need to go and define the relevant product and geographic market. So when we say define the relevant product and geographic market, these are two separate categories, but they're interlinked. So when you say relevant product, there are tests which the Competition Commission might engage with in trying to define the relevant product in this particular case. There is the statistical test which we call as SSNIP, small but significant non-transitory increase in price, or also called as a hypothetical monopolist test. So the test essentially asks if we take a particular product and we say, okay, if a firm producing this product can increase its price in a small manner, but in a non-transitory manner, all right, which means the price increase is not very temporary, it's sustained price increase. If it can increase this price and face no competitive restraint and therefore increase its profits, further maximize its profits, then in that case we say, well, you know what, there is no other substitute product for this. Hence, they're able to increase their prices by 5% or 10% and get away with higher profits. So therefore, this must be the relevant product. But if they increase their prices by 5% and the consequence is actually that they may reduce their profits, then we say, you know what, there are other products which are substitutes to this product, and we must include them as well in the relevant product market, right? Until that collected set of products, when a hypothetical monopolist for that collected set of products increases the price by 5% and finds that it's profitable. I mean, you can actually increase your profits, you can maximize your profits further. Well, at that point, we say, yes, we stop at this particular point. This is a relevant product. There are no other products which are close substitutes so as to place a competitive restraint. All right. And similarly, now after defining the relevant product market, then we ask, okay, what are the set of buyers and sellers who are present or who actually interact uh, in actuality as well as potentially interact so as to define the relevant geography. So all those areas from where you have buyers and sellers interacting actually and potentially will have to be included in this particular relevant geographic market. All right. So The details for defining relevant product and geographic market are outlined in section 19.6 and 7. All right, so first we define the relevant product and geographic market. Then we, after defining this relevant product, then we try to see what is the market share of this firm. So now in some cases, there are trigger points. We say, what, if a firm has a market share of more than 30%, then, we need to go further and see if they are, and look for other factors of dominance. In some other cases, there may not be any bright line, but nevertheless, we could safely say that if a firm has a large market share, 40% or 50% or more, the commission would usually like to look into other aspects of dominance. All right. So what this means is that the market share acts as a filter mechanism. If you have a high market share, then the commission is likely to go deeper and look into the other factors which are relevant for establishing dominance. Okay? So it does mean that market share alone is not sufficient to establish dominance. So what are the other factors that we need to establish dominance? We need to look at size and resources of the enterprise, or the economic strength of the enterprise, size and importance of the competitors, and economic power and commercial advantages it has over the competitors, and also very importantly, entry barriers. All right, now that's going to play a very crucial role over here. We'll try and look at what are the entry barriers in the case of the mobile ecosystem. All right, and then of course the overall catching clause that the Act provides, any other factor which the Commission may consider as relevant for the inquiry. So if after having defined the relevant product and geographic market, we find that the firm has a large market share, then we look into all these other factors. And then if we finally say, okay, based on all these factors, we feel that this firm actually has dominance. All right. So when we say dominance, what we really mean is that the firm has no competitive restraints on it. It can increase its prices in a profit maximizing manner without any other firm acting as a competitive restraint. So now, after all of this, we need to establish if there has been an abuse of dominance. So just being dominant or a large firm in itself is not a crime. What is important is whether the firm has abused this dominance in an anti-competitive manner. All right. So when we say abuse of dominance, we can broadly categorize these abuses into exclusionary abuses and exploitative abuses of dominance. Right. So now let's go ahead and see what the EU Competition Commission found with respect to Google in the European Union. All right. So firstly, with respect to dominance. So in the case of the EU, they found Google to be dominant in 3 different markets. All right. Firstly, the market for general internet search services. Secondly, in the market for licensable smart mobile operating systems. That is, of course, its licensed Android operating system. And then app stores for the Android mobile operating system. So in all 3 of this, the European Union found Google to be dominant. Of course, it did look at the market share, and in this case, it found the internet search market share of Google to be more than 90% among all the European Economic Association member states. And in the case of the operating system, more than 95% of the smartphones, ran on the licensed Android operating system of Google. All right. So, and then in terms of the apps downloaded from different app stores, it found that Google's Play Store had the largest possible number of downloads of apps. So based on all of this, of course, we could say, what, a 90% market share or a 95% market share can actually indicate that Google has a substantial market power, because this really large market share. But then even then, if you do have a large market share, it still does serve a purpose, particularly in technological markets, to just check for whether this market share has been sustained, and whether it's a technological market where there are rapid changes in technology such that a new upstart could very easily displace a dominant firm. Okay, so it still serves to actually look into other factors. And what are these other factors? We would like to know if whether, firstly, there are high entry barriers, all right, in these markets, in these relevant markets. So if there are high entry barriers, well, it essentially means that new firms will not be able to easily come in and compete away the profits that Google enjoys, right? Now, in the mobile operating system, so what we are moving towards to is that in the case of the EU Competition Commission's findings, they find that actually the mobile ecosystem does not seem to have a competitive at most. Why? Because there's this one dominant firm, and this dominant firm, maybe possibly, abusing its dominance, right? So, how is it that it's dominant? What allows it to sustain its dominance? Two important aspects over here. One is the network effects, and the second one is a behavioral aspect that we call as a status quo bias, right? So, network effects, most of you would be familiar with. Um, the Android operating system, sort of a first mover in 2005, Google realizes that, you know what, people are not just going to be surfing the internet on their computers, but rather increasingly they're going to start using their smartphones for internet searches. So it buys out this Android operating system way back, develops upon it, and is a sort of first mover among the smartphone operating system providers. And then starts the network effect. So being among the first and good operating systems, more and more, you have these indirect network effects sort of building up. As more and more phone manufacturers, original equipment manufacturers, decide to use the Android operating system, more and more app developers would prefer to develop apps for the Android operating system. And as there are more and more apps, more and more people would like to buy phones with Android, because I like the fact that there are so many apps that they can download. And as more and more buyers of phones, as there are more and more Android phone buyers, Android operating system based phone buyers, there'll be more manufacturers and there'll be more app developers. So it sort of creates this snowball effect, right? So therefore, once this starts growing and growing and growing, it becomes very difficult for a new entrant to position itself, because when it comes in, app developers would not want to develop an app for them, because why would I want to spend so much of fixed costs in order to develop an app for a phone based on a different operating system which hardly has any users, right? So, and then if you don't have so many apps to download, then your operating system is not going to be considered great, and people would not want to buy a smartphone with this kind of an operating system. So network effects acts as a huge barrier for new operating systems to come. All right. Now, then the other question that we ask is, okay, then there are other things that Google does. It doesn't just have an operating system, but it also insists that those who use its licensed Android operating system must also mandatorily include with it the Google search, as well as the Chrome, and as well as the Play Store. The Play Store comes, pretty much all of these come packed within the operating system. So they have no choice. They have to include all of these apps and the search engine of Google within this particular phone. Now, what does that do? This sort of takes us back to the early Microsoft case, where Microsoft used to bundle its Internet Explorer and was fined very heavily for it, because it was found to be exclusionary. It was found to exclude competitors, right? Now, here in this case, similar sounds come out of here. You notice that Google's inclusion of Chrome and its Play Store leads to the exclusion of other, you know, other types of app download systems as well as search engines. All right. So, and now the question is, okay, so what if it is preloaded? Can't people still download, something else? Can't they download another Play Store like a Samsung Play Store or something else? Uh, no, I don't call it Play Store, App Store rather. So, but however, people don't. All right, and the reason why people don't is because of a behavioral factor, which you call a status quo bias. Inherently, behavioral studies find that human beings are lazy. They tend to stick to the same choices over and over again and refuse to shift to new choices, simply because they don't want to undertake the minimal cost that may be necessary to learn how to use something new. All right, but nevertheless, the status quo bias is quite strong. So because of both of these, the network effects and the status quo bias, apart from the other reasons, and the market share, Google was found to be dominant in these markets, right? So now the next question was, so did Google abuse its dominance? Well, yes. There are several ways in which Google abused its dominance in trying to exclude competitors, all right, and continue to retain its dominance. All right. So how did Google do that? Well, firstly, there are three ways in which it did this. All right. Firstly, it required all smartphone manufacturers to pre-install Google Search and Google Chrome on Android devices. So this was mandatory. And as we just discussed, once you install them, then people don't use alternate searches. They don't bother to download some other search engine and try to use that for searches. Now, that's a behavioral aspect. Now, the question, of course, we can ask is, is that just a hypothesis, or was it tested? Well, the Competition Commission actually tested it. It compared it with Windows phones, and it found that in the case of Windows phones, where there was no such um, forcible packaging or tying in of Google Chrome and Google Search, they found that Google Chrome was, just about used by 25% of the internet searches. All right. So therefore, they concluded by saying that, preloading Google Chrome and Google Search has actually led to the exclusion of other competitors. If it hadn't been preloaded, people wouldn't have chosen this and they would have chosen something else. I'm just keeping this very brief. And then the second way is what Google did in order to further prevent the possibility of other potential operating systems. Now, Android is an open source code. Google develops its version of Android, which comes with all Google services, and no doubt it's a fantastic product. And then you also have the versions developed by others, which is called as Android Fork. Now, Google was found to be paying manufacturers to pre-install Google Search exclusively. Now, what would happen is if Google is paying them to install Google Search exclusively, then it would be very difficult for anyone else to offer their own version of the Android, because these companies would stand to lose huge sums of money which Google pays them. So even if someone were to offer it for free, they wouldn't want to take it because they lose out on the payments from Google. So effectively, it just blocks out any other developers of uh, either the Android fork or any other um, operating system. All right. So it was for Google's the operating system, and as well as for Google Search exclusively. They also paid them for installing Google Search exclusively. All right, so just correction. So they paid to install Google Search. All right. So therefore, it effectively prevented any other potential competitors from coming in and displacing Google Search over here, even if they were to try and offer it in a free manner. All right, and then thirdly, um, the way in which it sort of caused an effect was, they also sort of, because of the preloading of the app download software as well, it also prevented alternative app stores from coming in and acting as a source for downloads of apps. All right. So in both these manners, so it paid them for pre-installing Google search, and it also by way of the entry barriers, it sort of restricted other open source versions of Android. All right, so it entered into agreement saying that no other versions should be used as well. So how does this affect the consumer? So we want to understand ultimately competition is good because it leads to innovation and it leads to lower prices, right? And consumers tend to benefit. Now, because of all these anti-competitive acts of Google found by the EU Competition Commission, they said consumers are therefore losing out. How are they losing out? They have fewer choices between operating systems. All right, they have fewer choices between browsers. All right, and they also have fewer choices between sources from where they can download apps. All right. So in all these ways, and also fewer number of search engines for consumers. So in all these ways, choices are restricted. All right. And one could also say, okay, is it just a question of choices being restricted? We could also say in some ways that there is also a price, right? Now, Google doesn't charge anything for its licensed Android operating system, but um, there are, this is a platform. And in the case of a platform, we don't just look at zero pricing in one segment and say that that is potentially anti-competitive because it's predatory pricing. We look at the various other sides of the platform through which Google makes its revenue. So Google makes its revenue substantially through two sources. One is through advertisement revenue that comes about through the use of its search engine and the data that it generates from that, the targeted ads that it's able to provide and therefore make revenue, and also through the revenue that it gets from apps downloaded from its Play Store. All right. So both of them put together account for nearly about 180 billion US dollars annually. That was revenue at least in 2020. All right, now coming to the Indian context, so the question here now is for the Competition Commission is whether Google is dominant in the mobile operating system and also in the market for mobile operating systems and in the market for app stores. All right, so these are the relevant markets. And then the second question is, does it engage in abuse of this dominance? So when you say, does it engage in this abuse of dominance, the question that you're more specifically asking is that, does it engage in margin squeeze? Does it engage in very high pricing, which tends to exploit those who use its operating system and app stores? And does it engage in exclusionary practices, which essentially means by insisting on its own apps being preloaded, that is its search engine and its search engine and its Chrome app, does it lead to the exclusion of alternate uh, apps? All right. No doubt, even over here, Android does appear dominant. Why? What are the factors which are in favor of us reaching a conclusion saying that it's dominant? Firstly, it has a very large market share. All right. And we will soon see the market share statistics. And then in terms of entry barriers, very strong network effects over here too. No doubt, it doesn't mean that it's going to be any different in the case of India. And there are very low competitive restraints, particularly from the buyers. The buyer power is very low, and it also has substantially large economic power. What are the factors which can actually pose competitive restraints? It's a tech-driven market, rapidly changing, things that are taking place in this mobile ecosystem. Um, and then there is this 5G and this kind of technology and phones based on 5G. If they start with a new operating system, then it could pretty well start a new network, and these OEMs need not at all adopt Android, and that can threaten its network. But as of now, both of these don't seem to threaten Google, as we will see, due to various reasons, particularly due to acquisitions. All right. So let's see what exactly is the market share over here. We have about 760 million smartphone users, the millions missing there. and 450 million internet users on the mobile in India. All right. Um, and if you look at the market shares over here, the way in which it's been changing in India, um, you look at the growth of Android from January 2012 to November 2020. That's a huge increase. All right. So when you look at this increase, you see a market share of 95%, and you say, well, the screening factor here pretty much points to the Android operating system being the dominant operating system. All right. And then, of course, the market share is quite consistently increasing and is also very high. One of the other factors that we need to look at is whether the market share is fluctuating. Does it go high one year and does it then crash the next year? We want to look at consistency in the market share and whether it continues to be high. So if it continues to be high, then a derivation from that can be that there are entry barriers which allows this firm to continue to remain on the top. So looking at the revenue aspect over here, um, the revenue that Google derives globally from its mobile operating system, and therefore also tying in its search engine there, it derives at least 145 billion through ad revenue related to searches. But this is not just about smartphone searches, it's also generally about searches even from computers. All right. So, but its revenue from ads, targeted ads, which is based upon the data of internet searches, is about 145 billion, and revenue from Google Play Store is about 40 billion. So these two play a very important role in as to why Google might have a valid reason to maintain its huge presence and prevent a competitor from coming in. All right. So, all right, so we said market share is quite high up there. What about the other factors of market power? Let's have a look at that as well. All right, so indirect network effects, very strong. In terms of economic power, 187 billion in revenue and a 1.5 trillion in valuation. Very few firms can challenge this kind of economic power. And then huge sunk costs in a tech market like this. Enormous amounts of funds have to be invested in research and development. And that kind of funding, very few firms can afford. And as a consequence, even if there are very few firms, startup firms, some people might argue, oh, you know what, it's very easy to actually develop an app, or try to actually come up with a reasonable operating system. Even if someone does say that, it's very difficult to generate a network, all right, and to enter into a market like this. So what it results ultimately is you see a lot of startups actually selling out of a couple of years, either because that was the intention, that was the exit strategy, that they wish to build something and monetize that by selling it out, or because simply they just can't compete against these large players. So if you look at Google and of course the other tech firms as well, there are a huge number of acquisitions, substantial number of acquisitions. But of course, because the firms realize that tech innovation can very quickly change the market status of a leader. So they're very keenly looking out to see what are the new things that are taking place out there, and any interesting development there, they're quite willing to get in and buy it out. All right. So all of these, have had a contributory factor to ensuring that Google continues to remain dominant. And one important evidence in that is a long sustained market share. All right. And of course, another evidence is the inability of newcomers to get into, say, the App Store or even the operating system market. There was this Indus operating system which was developed in India, which at one time saw a large number of users of this operating system, but then it just failed and it exited the market. But it continues with its App Store. And similarly, Samsung too tried to develop its own version of the Android. But however, um, it's not just about making an Android version of your own, but it's also about the analytics and the other kind of tech support that Google provides for its Android operating system, which Samsung simply doesn't enjoy. And more than that, it's also about the apps which will be available on Samsung's own version of that operating system, which would be very, very few. All right. And so the network effects would be really very small in that particular case. Right. So the other thing that is lacking is buyer restraint. All right. So when you say buyers, of course, we're talking about the smartphone manufacturers, the original equipment manufacturers. And they obviously they're not buying the operating system from Google. They're getting it for free. All right. So even if they're getting it for free, they know pretty well that Google's, um, profit strategy is not from the operating system. Its whole purpose was to allow for the operating system to be given free and allow it to be used by a huge number of users of smartphones so that it grows into a huge network, and that network allows it substantial opportunities to monetize its investments. So how does it monetize its investments? This is exactly what Google claims. It says that, look, we provide the Android operating system for free. And in order to recover our investments or in developing this operating system and the support that we provide for this, this operating system, we insist on, the our search engine being a part of the phone and Google Chrome also being a part of this phone, and that our Play Store be used exclusively, right? That allows us to utilize, to recover our investments, is what they would argue. All right. But so in this case, when you say buyer restraint, the smartphone manufacturers have very little restraint in terms of, telling Google, what, we don't want to preload your Google Chrome or your search engine. We would prefer to, put in something else. That's simply not possible because of the size of the network or because of the large number of buyer base for Android phones. They simply cannot do without the Android operating system, the licensed Android operating system. All right. So if you look at the smartphone market, you see a number of players there competing. And there are, of course, different segments. I won't go into the details of all of that. So there are different segments there, but you could say the low end, mid end, and the premium market. And in the market for phones, smartphones, which cost below 400 US dollars, and that's the fastest growing market, of course, the Android operating system dominates. It's the largest player there. And in the ultra premium market, there too, it's a large player, if not the largest. That's where the iOS operating system of Apple comes into play. So therefore, if you look at all the segments of the smartphones, Google is a big player, and the buyers, the original equipment manufacturers, have very little buyer side restraint on these firms. So therefore, the next question is, all right, so Google is dominant, through all our analysis. Now, the next point is FX analysis. Now, although in section 4, abuse of dominance, it's a very formalistic sort of a legal requirement. It says, okay, you establish dominance and then you establish abuse of dominance. You don't really have to go into an FX analysis in the sense that you have to show that there has actually been a negative effect on consumers or a negative effect on other competitors. All you just got to do is to show that there has been an abuse, and that in itself is sufficient. But there's a whole amount of literature out there which says that in certain cases, when markets are more complex to define, it might just be better to get into an FX analysis rather than get all wound up in terms of trying to define a relevant market. But nevertheless, we can look at the effects over here too. What are the potential effects that it can have? All right. So over here, with respect to original equipment manufacturers, we can say pretty much they have no choice between what kind of a search engine they have to use, and between also the Chrome and other kinds of apps that compete with it, and also with respect to the app download also with respect to any competitors for the Play Store. Then how does it affect other people in the ecosystem? How does it affect app developers? In the case of app developers, of course, if you're a free app, well, then there's nothing much that you really got to look for in terms of being negatively affected. But there are many apps there which involve payments, and there are many apps which involve recurring payments too. Now, in this case, the question is whether they are charged a very high price. We'll just have a look at that soon. And then the other question is whether their data is compromised. All right, so not saying that the data is compromised, but these are questions that we need to answer. And then how does it affect consumers? The simple question is, by virtue of it being dominant and by virtue of it blocking competitors, does it hinder choice for consumers? So the Competition Commission usually looks at whether consumers will land up paying a higher price, firstly, and secondly, whether consumers will have to sacrifice either quality or variety of the products that they can normally choose. So all of these are important questions that the Commission will be looking forward to analyze. In terms of app developers, we can try and look at two kinds of potential effects that can come out. One in terms of exploitation, and the second one in terms of exclusion. In terms of exploitation, the question is, what do they have to pay Google? All right. Well, Google charges, at least it is charging in other countries, at least 30% of their transaction fees. All right, so let's say there's an app, you have an in-app purchase, and you pay 100 rupees for something. You have a particular game, and the game requires you to, okay, you want to continue a game, why don't you buy some lives, let's say. Okay, so you're playing a game which involves lives, and if you want more lives, you have to pay a certain amount of money. Now 30% of that goes to Google. Right now, the question is 30% a fair price? Is that an exploitative price? Now, what do you compare that with? Now, interestingly, Apple and Google both have the same percentage of transaction fees in the US too. Okay, for revenue transactions which cross 1 million in the US. All right. So they both seem to have similar percentages of transaction fees. So if you want to, if you allege that there's exploitation, now the question that comes up is, then what is a competitive price? If it's not 30%, then what should it be? All right, and that's a question that becomes very difficult to answer. All right. Now, anyhow, so with respect to app developers, app developers, obviously, they want to develop apps for the largest network. Why? Because of simple economies of scale. Once you invest a certain amount of sunk cost into developing an app, well, you might as well ensure that it reaches the largest number of people, which, lowers your average cost, right? But since Android is the largest, opted operating system, they prefer Android. Now, why can't they also develop for, iOS? Now, it's not so easy trying to develop. It involves expenses, again, repeated R&D to try and develop the code for both the operating systems. So statistically, we find that only 9% of the apps are there on both platforms. And even though they're there on both platforms, you actually see a functional difference. And when I say functional difference, I mean qualitatively different on these platforms, which just shows that they're actually more heavily focused on one platform, and they relatively neglect the other operating system. All right, so these kinds of sunk cost investments which are required prevent an app developer from trying to be present on both the platforms simultaneously. All right. So therefore, choice is not, they don't have a choice of operating systems. It's Android, which is the largest chosen over here, and therefore they just prefer to stick to Android. So once you have no other choice, then it becomes easy for Google to charge a high transaction fee. But then the question that comes in is, so what is the correct fee? Now that's a question which needs to be answered. All right. So this transaction fee is applicable in India as well, but Google has said, okay, we're going extend the time till March 2022. From then we will start charging a 30% transaction fee. All right. Then the other one is in terms of exclusion. Now, Google has its own wallet. All right. So Google Pay is there, and Google Pay competes with Paytm and Phone Pay and other wallets, other e-wallets, right? Now, sometime back, you know, uh, Google just, Android just removed Paytm. It just banned Paytm for some time. All right, saying that it was violating its gambling policy. Now, when it bans Paytm, very interesting questions that come up because Paytm is actually a competitor to Google, right? So, if Paytm is banned, now does it mean that Google Pay is actually going to benefit from this? Now, we don't have the data, but data could possibly reveal whether banning of Paytm led to users to shift from Paytm to Google Pay. All right. If that led to a huge shift to Google Pay, then we could say that Google Pay was the closest competitor and the largest beneficiary um, of Paytm being banned. All right. Now there's a bit of an information asymmetry here. All right. Did Google disclose all the reasons for banning Paytm? That's one aspect which the CCI may want to look into. And secondly, does this kind of banning actually lead to shifting of people or users from Paytm to Google Pay, and therefore it being the beneficiary? And another question that we might ask is, once that ban has ended, do people shift back to Paytm? All right, now here's a factor that we need to consider, what is called as switching costs. So are there switching costs which prevent people from switching back to Paytm? All right. So when we're considering exclusionary practices, we also need to consider the aspect of switching costs. If switching costs are high, then in cases like this, when there is a temporary elimination of a competitor from the App Store, people may not just, they would refuse to move out of Google Pay and go to an alternate wallet, all right, e-wallet, all right. So how are competitors responding? How are app developers responding in India and the US? They are trying to respond by setting up their own coalitions, trying to promote alternate operating systems or alternate um, app stores, but so far none really so strong in terms of providing a competitive restraint on Google. All right, so I'm going to stop with that and take questions. So what I've just broadly trying to paint over here is the potential questions that the CCL probably have to answer in trying to consider whether Google has actually has dominance and has abuses dominance, and what are the kind of anti-competitive effects that it may have for the various participants in the mobile ecosystem. Okay, so should we take some questions now?
Professor Shubhi will be relaying the questions to you.
Okay, sure.
Sir, it takes a while to get the question, so I'm just waiting for that.
All right, sure.
So we have one question, and that is, when does price discrimination by dominant firm amount to an abuse of dominance?
Yeah, sure. It's a good question. Price discrimination, when used in certain manners, can lead to exclusionary effects. Like, say, for instance, you can say that Google offering sums of money, like, say, for instance, Google actually some people could ask whether um, Apple iOS is a competitive restraint on Google's Android. And we said in the super premium category, Apple's iOS is a large player. But then Google pays Apple huge amounts of money, all right, huge amounts of money to use its search engine. $6 to $12 billion reportedly per annum, so that its search engine is used. So effectively, Apple search engine also does not provide a competitive restraint because it's Google's default. It's the default search engine is Google. Now, why am I talking about this? When a dominant player pays off, other people in the vertical chain to use its product, it in ways it acts as a price discrimination. Okay, they can use this as a price discrimination methodology. How so? They can actually tell, a manufacturer can tell, say, a retailer that, look, if you use, if you sell only my products, I will give you this discount, right? And to other retailers, it will not engage in this kind of price discounts. All right, so there is a price discrimination between what it offers to different types of retailers. Now, this discount is not on any economic basis. Rather, it's based on a simple exclusion aspect. All it says is that you keep out other competitors, you don't sell any other competitors' products in your store, and I will give you this particular discount, right? Now, and for others who deal with all the other products, not just this vendor's, this manufacturer's product, but also other manufacturers' products, they don't get this discount. So there is a different price which is, at which it's sold to these various retailers. So you could say that the retailers face price discrimination over here. And this price discrimination is actually anti-competitive because it leads to the exclusion of certain sellers from these retailers' store. All right. I'm just trying to uh, keep it as simple as possible. All right. Okay. There's a question up there. What kind of those common fraud process of transaction often witness? What is your call on it? Not able to completely grasp what it is. Could you probably rephrase this with the kind of those common fraud process of transactions often witness? What is your call in it? Okay, you're talking about fraud issues. I'm not sure if it's a competition issue or whether it's a consumer law issue. But if, okay, just coming to e-wallets, I'm just trying to tie it into e-wallets. If you're talking about frauds and glitches in e-wallets, and whether firms tend to benefit from that. Now, if switching costs are very low between e-wallets, now most of us find it very easy to download all the possible e-wallets, the largest e-wallets that are present in India, maybe PhonePe or Paytm and Google Pay, right? And we probably use all of them, at different instances. One doesn't work, the other could be used, and so on. Now, in such circumstances, if one resorts to any kind of such acts, it's very easy to shift over to another particular wallet. So if switching costs are low, such acts are not so easy to pull off. You have to be your competitive best.
Thank you, sir. There is another question from Mr. Sandeep. He is asking, sir, how far free and open source software can be a solution to the market dominance by Google and Apple? Is there any scope for the government to promote FOSS applications and operating systems as a counterbalance to the problem of market dominance in IoT ecosystem?
Well, the first thing is that you already have this Android. Android is an open source, right? So you can develop upon this Android open source and try to, and OEMs can use this. But as I pointed out, there are barriers to this in the sense that even if you do develop this operating system, who's going to develop apps for this operating system? So there's this network effect issue over there, right? So And even if you do develop an operating system, one of the things that we must understand is that the operating system is extremely crucial to the functioning of a smartphone in terms of the battery life, in terms of the phone heating up, in terms of the speed with which the phone operates, in terms of the data analytics that the OEM manufacturer gets in order to, you know, develop its product. All of these are very, very important. And that requires an enormous amount of back-end investment and constant technological support. If you cannot provide that, then it means that it's not just about network effects, but it is also about the intrinsic value of the product or the quality of the product, which may also let you down. So you have to compete not just in terms of network, you also have to compete in terms of quality and the type of sunk cost, the amount of sunk cost that is required to ensure a qualitatively competitive product to Google's Android is phenomenal. I hope I've been able to answer your question.
So Sandeep sir is further asking, can the government through regulation fix a fair price?
Well, the question is, fix a fair price for what? You know, the operating system is free. The search engine is free. And of course, we have a charge in the case of app downloads, which require payments or, you know, recurring payments through apps. Now, if you ask a question as to whether the government can actually charge a price for that, well, government can actually fix a price for that. Well, then, as I pointed out, the question is then what do you think is the fair price to charge? All right. And how often should you review that particular price? So it's not going to be easy to answer that particular question. All right. But then in the other two aspects with respect to the search engine and operating system, they're all a part of the ecosystem. The question is, you know, Google gets its revenue through ads, right? So the question that we have to ask is whether Google is enjoying supra competitive profits, all right? But even that may not be sufficient. So what we have to ask is, what is the price that we are actually paying? You know, we are not paying anything to use the search engine, but there is a price that we are paying in terms of the information that we are giving up. So the regulations that we need to see is in terms of reducing barriers to entry into the operating system, is how this data can be utilized in a better manner and not be the sole and exclusive preserve of Google, so that new entrants might be able to utilize this data to, you know, develop at least intrinsically qualitatively good products. All right. So that is one way in which the government is trying to help make data accessible to all. But then there's a danger. There's always this danger in the sense that if you go too far into that, you affect a firm's willingness to invest in, you know, generating and analyzing data. So that becomes a huge problem. I hope that answers your question.
Thank you so much, sir.
Any other question, please go ahead.
No, sir, I don't see any other question. So we can start with your next session on economic analysis of crime with relation to India.
Okay, sure. Thank you. All right, so in the next session, I'm just going to keep it very, very interactive. All right, I want to be as interactive as possible with respect to this topic as well, but let's keep the session coming up as more interactive. I'll just take a minute off and I'll get back. Is that okay?
Sure, sir.
Yes, sir.
Okay, I'm back. Let me just get out some elementary slides for this. Okay, I think we can start. Um,
Yes, Professor.
I'll just share some essential slides if required. Otherwise, I won't get into slides at all. But I understand that there's already been a session on economics of crime, law and economics of crime.
Yes, sir. We had it yesterday.
Okay, great. So in that case, I'll just go through the elementary aspects and then we'll try and apply it to certain contexts, right? Okay, so I'm sure you would have all had uh, got some brief exposure or great exposure to Gary Becker's theory of crime, and where Gary Becker basically is assuming that the decision makers or the people who commit crime are all rational. All right. So now, when we come to crime, um, you know, we say, law and economics, are both um, perfect complements to each other because law essentially seeks to induce desirable behavior among individuals and firms so as to bring about a better society, bring about faster economic growth, sustainable economic growth, and so on and so forth. All right. Um, and economics is about the choices, is about the study of behavior of individuals and firms, um, under settings of constraints, and under the assumption that they seek to maximize their benefits and returns, right? So individuals and firms all have constraints, and at the same time they have several wants, and so therefore the question now is, how do we maximize our profits in the case of firms and our satisfaction in the case of individual consumers, um, with these limited resources. So that maximization of our own satisfaction or maximization of profits on the part of firms is what we describe as the behavior of rational decision makers. So rational decision makers are always seeking to maximize. All right. And there are other, of course, assumptions about rational decision makers, but this is a primary aspect of rational decision makers. So therefore, now in the theory of crime, we are assuming those who commit crime, acts of crime, are also rational decision makers in the sense that the whole purpose of committing crime is to maximize their benefit. All right. Now, of course, when you commit crime, there is always the probability of you getting caught. So, therefore, I mentioned the word probability, right? So when I say probability, it means that I'll take a simple instance. I'll take the instance of um, um, violation of traffic signal rules. So you see a red light, and in reality you're not seeing red but you're seeing green, and you jump the light. That's very common in the case of Indian cities. All right, somehow Red always seems to make you get more excited and you seem to just move past, the signal. So you may do that once, you may do that 10 times, you may do that 100 times. And out of these 100 times of jumping a red signal, you get caught once, right? So if you get caught once, it means that 99 times out of 100 times, you manage to get away. So the probability of you getting away with this violation is 99 by 100, which is 0.99, right? So that's the probability with which you're going to get away with this particular crime. And then the probability with which you will get caught is 0.01. Okay, that is 1 by 100. Now, how do we, so we have the probabilities now. Now, what Gary Becker's theory of crime assumes is that a person who's going to commit this offense or any other crime is going to calculate expected benefit and expected cost and then get the net out of that. And if the net benefit is positive, then that person is going to commit that crime. Now, what is the expected benefit? Well, the expected benefit is nothing but the probability of you getting away with this crime and the benefit you derive from it. So let's say in a simple manner, the probability of you, we already calculated, we said it's a 0.99 probability that you'll get away by jumping a red light. And let's say the benefit of that is 1,000 rupees. Okay, we're just monetizing that. We're saying, there's a potential benefit of 1,000 rupees. It could be anything, right? So if it's 1,000 rupees, then the expected benefit is 0.99 into 1,000, which makes it 990 rupees, right? So in a sense, expected benefit is nothing but the average benefit that you will get for every instance of jumping the red light. All right, so that's how you can interpret expected benefit as. And then you have the expected cost. Now, when we say cost, it is something that you got to pay, right? So if it is something that you have to pay, then it's a negative amount. So now in this case, there's a 0.01 probability that you will have to pay the penalty of jumping a red light. And let's say the penalty is 1,000 rupees. So if the penalty is 1,000 rupees, the expected cost is going to be 0.01 into minus 1,000. So I'm going to show you some numbers, of course. You'd say, gosh, how is all this supposed to go in without it being put out in writing? I will show you something in a written format for an application, right? So it's 0.01 into minus 1,000, which effectively makes it, you got the numbers, it's minus 10, right? So it's 990 minus 10 rupees, which makes it 980 rupees. Expected benefit plus expected cost, the expected cost being negative, makes it 990 minus 10 rupees, which is 980 rupees in terms of net benefit. So in this case, a rational person would say, fantastic, no big deal. I'm just going to jump the signal. All right. And in fact, many a times you do see firms actually behaving in this manner. All right. Now in the US, there is this instance of a courier company, like you have these big companies, DTH and FedEx and so on. So they had to, deliver these packages across the city. And in trying to deliver these packages across the city in an unhindered manner and to ensure a faster turnaround time, they had to park in areas which were uh, non-parking zones. And as a consequence, of course, they would be served a ticket and they had to pay a penalty and so on and so forth. Rather, what they did was they just approached, the municipality, the civic corporation, and they said, you know what, just give us this many tickets per annum. We're going to buy it beforehand. So in a sense, they were behaving rationally as they assessed and said, you know what, it's actually to a net benefit to violate this particular rule. All right. So that's what Gary Becker's theory is essentially telling you, that those who commit offenses or acts of crime actually behave in a rational manner. And by behaving in a rational manner, we are able to predict, therefore, the law and economics perspective is able to predict how people will make their decisions under a set of restraints or under a set of incentives and disincentives. So the question therefore here is whether our incentive structure is correct or wrong. All right. And now when we looked at this whole equation, okay, so I think it's time to show uh, a particular slide. So when we looked at this whole equation, we said, there are two factors that are involved here. The first factor is probability. Okay, the probability of being detected in committing this offense. And the second factor is the cost of being caught in this particular act. So if you were to increase the probability of being detected, or if you were to increase the cost or the penalty that would be levied when you were detected, both of these could increase the expected cost, and therefore what could happen is that you could deter a rational criminal by making the net benefit negative. So in this particular case, you may want to increase, if the penalty is 1,000, maybe you want to increase the penalty further. Maybe you want to increase it to 10,000, or maybe you want to increase it to 1 lakh. Okay, so if you increase it to 100,000 rupees, then with a probability of 0.01, you can make the net benefit negative and therefore deter, uh, any such crime. All right. Now, my question, and for discussion, what do you think of this? Very simple. So Gary Becker's theory of crime would tell you that, just focus on increasing the probability, just focus on increasing the penalty. And once you increase the penalty, the expected cost will go up, and voila, you've taken care of the problem. So is that okay? Discussion time, questions.
Professor, there could be cost implications.
Yeah, yeah, there would be cost implications in terms of increasing the probability, in terms of increasing, but there is cost implications if you were to increase the probability of detection. But in terms of increasing the penalty to 100,000, yes, there would be other cost implications, but in a more precise manner, what would this 100,000 rupees mean? I mean, I'm trying to lean more towards a behavioral perspective. All right, so let me ask a question therefore, and yeah, probably open it up to vote. So I'll give two options, option A and option B. And you can just put up your options. So all those who prefer option A can just say A, type in A. And all those who prefer B can just type in B. All right, so option A is that a parent decides that the best way to discipline a child is that every time the child commits an errant act or a truant act, the parent holds up the child and disciplines the child by rebuking the child, mildly rebuking the child, or that is option A. Option B is the parent neglects the child, for every act that it does, and then one fine day catch the child and thrash the daylights out of the child. That is option B. All right. Which option would you prefer? Voting time. How many would prefer option A and how many would prefer option B? Okay, of course, participants on YouTube will not be able to provide the option, but at least those who are here are saying that they would prefer option A. Yes, so when you choose option A, what you're indirectly telling me is that even when we apply Gary Becker's theory of crime, you cannot always focus on just increasing the penalty. As Professor Anita has already pointed out, there will be costs, and the costs are essentially sort of normative costs that we're talking about. When you impose such high penalties, it could have a very iniquitous effect on the society. It's quite possible that those who can still afford it will continue to break the law, but there are others who cannot afford it. Essentially those who are poorer, on whom such a penalty can have a huge impact. You break the law once and you have to pay this huge penalty of 100,000 rupees. They'll just say, you know what, just keep the vehicle. All right, I cannot pay that particular penalty. And if you were to take that vehicle away from that person, it might just affect that person's livelihood and therefore have quite an iniquitous effect. So just focusing on increasing the penalty alone is not a solution. We also have to look at the other aspect of the expected cause. We also need to look at the probability of detection. And as you would have already pointed out, as you would have already seen in your earlier sessions, the probability of detection in this particular case could mean you focus on increasing the resources which will lead to greater detection. And what does that mean? Increasing the number of police personnel, increasing probably heavy reliance on technology, putting up cameras at more traffic signals, particularly where there is a higher density of traffic, and where the probability of breaking these rules are also higher. So both of these would increase the probability and therefore increase the expected cost, and therefore reduce the net benefit to probably the negative territory. All right. There are other assumptions behind this particular approach of Gary Becker, and the assumptions are with respect to a person's approach towards risk, whether the person is risk neutral or risk averse or risk loving. Here, the assumption is that the person who's committing this offense is risk neutral. All right, but we won't get into that particular complexity. Right now, having said this, I'm going to pause and take a couple of questions, and then we'll move into applications. Right. So, are there any questions? All right.
We have a question.
Would you like to? You have a question? Yeah, please.
Yes, that is, sir, how do we give numerical value to the commission of crime? For instance, if we apply this concept on crime of consuming cannabis, how do we qualify the qualitative reasons?
Okay.
How do we quantify the qualitative reasons?
Yeah, excellent question. Often when we talk about penalty or disincentives, we inevitably tend to veer around towards understanding them in terms of monetary quantities, but it need not always be monetary quantities. For instance, when we talk about incarceration or putting someone into prison or death sentence, you can't monetize that. But there are ways in which we can get approximations. All right. So law and economics are both social sciences. We cannot give precise values, but we can estimate them. So how do we estimate them? There are different ways. So for instance, a question could be asked, what is your maximum willingness to pay rather than do without that good? So in the case of this person whom you're talking about, who's committing the crime of consuming cannabis, well, of course, this is an addictive good. We're not talking about a normal good. And in this particular case, when we come to addictive goods, we're not even dealing with rational decision making. So probably the whole approach of of assuming rationality breaks down over here. But assuming for a moment that there is a person who's engaging in this particular act, that the question that we want to answer is, what is the maximum that this person is willing to accept rather than do without this good? All right. So that would be a way of trying to quantify what this particular act is worth to him. So if a person is supposed to be incarcerated, then what you want to understand is what is the value that this person would attach, um, rather than go, what is the value that you would be willing to pay rather than go to the prison. So there are these methodological ways, indirect methods through which we try to estimate what a person would on an average tend to value a particular act. I hope that answers your question. All right. Any other question? Do we have one more question, or should we proceed to applications?
No, sir.
Okay.
Okay. No, sir, we have one more.
One more.
From
Okay.
Jyoti Jindal itself. She is asking, sir, if you could brief about these methodological ways.
You mean of trying to quantify the value that people would attach to a particular act?
Yes, sir.
Okay, sure. Now, let's say, for instance, there are different ways, of course, and in certain, and you don't go about it in trying to use a survey. All right. So you try to use indirect ways. Like, say, for instance, we want to figure out, how to reduce pollution. All right. Then when we want to figure out how to reduce pollution, we want to understand how much should the government invest in terms of reducing pollution, because you don't want to invest so much that the benefit of the pollution reduction is less than the cost incurred in terms of reducing pollution. So therefore, in order to ensure that you spend an efficient amount in reducing corruption, an efficient amount in reducing crime, you want to understand how much do people value it. Now let's take an example. Let's say that in an urban area, there is a certain area which is by and large more polluted and all other things are the same. Or there is an urban center where by and large all of the things remaining the same, which means I'm talking about the same square feet or the same qualitative accommodation, everything remaining the same, excepting that the rate of crime is higher and or the pollution levels are quite high. Now you then compare the rental of that place to the rental of another place where everything else is the same number of rooms, the same square feet, and everything else is the same. But the amount of crime there is substantially less, and the air pollution there is also enormously less. Now you look at the rental that people are willing to pay there. You have to control for other factors as well. All right. But if you assume both of these are in demand areas, which are both equally close to the central business district where people travel to work, then you look at the rental difference over here. Now that rental difference is, the market which is acting. The market knows that people would be willing to pay a higher rental in these places rather than go there. All right. Because for everything else remaining the same, that place has higher crime or higher pollution. So over here, the difference in the rental can be a fair indication of what people, of the value that people attach to cleaner environment, and also the value they attach to a life with lesser amount of crime. So through these kinds of methods, we're able to indirectly estimate what people value, uh, certain acts, what is the value that they attach to certain types of acts. That's a very brief way about these methodological ways. Do you want some more examples, or does that answer your question? Okay. Jyoti Jindal, did I answer your question? Okay, thank
She
you.
says yes, sir.
Okay, great, thank you. So what should I move on to the applications, or do you want more questions? Methodological questions. Any other methodological questions? Okay. So should I move ahead?
Yes, sir.
Okay.
Because I don't see any more questions, sir.
All right. So I'm going to my first application now. And again, I'm going to keep it interactive. I know there are many people from a legal background over here. So I'm going to draw upon your learnings from this, and we're going to get into a sharing session over here. All right. Okay. Here we are. So here's my first application in terms of SEBI's insider trading regulation. All right. And we're going to try and apply Gary Becker's rational choice theory. I'm just applying some numbers over here. So the net benefit, and expected cost analysis is over here. But here's how it goes. So most of you have, some knowledge of insider trading, and we know insider trading is illegal because it gives uh, people who have price sensitive information an undue advantage when they decide to monetize on that information before it has been publicized. And they try to monetize on that by engaging in stock market trades. So for instance, if let's say Jet Airways, where it is right now, no one expects anything to happen with respect to Jet Airways. And suddenly there comes along a big buyer for Jet Airways, and no one knows it, but there's one person who's aware of it, or not just Jet Airways. Let's just say this: some of the similar company, which is really down there, huge, enormous amount of accumulated losses, and it's trading in the stock markets at a price which is below the par value, or which is below the issue price. So if the issue price, let's say, was 10 rupees per share, it's trading at, say, 10 paisa per share. All right. And then someone is interested, and they're in an advanced stage of buying up this particular firm, which is going to lead to this firm recovering substantially and doing really well. Now, that is price sensitive information. And as a consequence, if a person who has, access to this price sensitive information gets into the market and buys up enormous amounts of shares, uh, and then once this news is made public, the share price could jump from 10 paisa to 100 rupees or 200 rupees, meaning that this person who acted on insider information is going to make enormous amounts of profits. Now, you may have different arguments as to whether you should allow a person to do that or not. There's a huge amount of law and economics literature on insider trading and whether insider trading is efficient or not. But insider trading is illegal, all right? And almost every country that I know of considers insider trading as illegal, right? And so now the question is, how do we alter the incentives, assuming that a person who commits this offense is a rational criminal? How do we alter the incentives and disincentives such that we can't alter the incentives? We have to alter the disincentives such that the net benefit turns negative, and they would therefore not want to commit this particular offense. Now let's see how SEBI's regulations for insider trading have evolved. Now, of course, here again, when we look at SEBI's regulations, there are two aspects to it. One is the penalty, and the second one is the probability of both detection and conviction. So I'm putting those two together, and um, keeping it simple. So there should be two probabilities: probability of detection, and just because you're detected doesn't mean that you will be proven guilty. You still need to be proven guilty and then finally convicted. So you've got to multiply those probabilities together. All right. But we'll keep that simple. All right. So over here, therefore, initially what we saw was SEBI's penalty for insider trading was very, very, very low. All right. I mean, in an absolute sense, in 1990s, it was something like rupees 500,000 or 5 lakh rupees. Now, in an absolute sense, it might seem to be large. All right. But then when you look at the probability of someone even being detected, forget about being convicted, just detection, all right, was extremely small. Okay, I'm just taking a hypothetical number here. I'm taking 0.00000001 or something like that, which is 1 divided by 1 million. All right. So that's an extremely small probability of detection. Now, let's look at the net benefit under these circumstances. Now, someone who commits an offense like this has a probability of getting away, very high probability, 0.999 or a 99.999 percentage probability of getting away. We don't say percentage and probability, but there's a 99.99 percentage chances of getting away. All right. So, and the benefit, let's say, is enormous. All right. It's 100 million rupees. All right. When you multiply the probability of succeeding with the benefit, and you subtract from it the probability of getting caught and the cost or the penalty that you have to pay in that case, you'll find out that this is the net benefit situation. All right. The net benefit is enormous. The expected benefit is 9,999,000 or 999, and the expected cost is just 5 rupees. All right. So obviously the net benefit in those circumstances were very high. All right. So although you could not, now there is of course a problem over here. You could say, well, if you couldn't detect insider trading, it was very hard to detect insider trading, then how do you know insider trading was taking place? All right. So that is a good question to ask. But then again, we do know that if this kind of, going by human rational decision making, we do know that if people knew that there was this phenomenal opportunity to make money and get away without being caught, that there would have been plenty of such instances. It's not that SEBI didn't detect, SEBI did detect, but however, its conviction was just abysmally low. In fact, zero. Till date, SEBI's ability to convict anyone in insider trading is still at zero. Okay. So now, what needs to be done? Over a period of time, SEBI's insider trading regulations have changed. There are many things that need to be done in order to ensure, one, that detection increases, and secondly, that conviction increases. All right. Now, for detection to increase, you need to, increase this probability here. Now, the way in which you increase this probability is by, better supervision. So if you look at stock markets now, they're all electronic, all the transactions are electronic. So your digital signatures are all there. So unusually large transactions just about the date when, there's some news, price sensitive news going to be reported, can trigger off SEBI's detection, and they might say, oh well, hold on, this is quite, why would anyone want to buy this particular stock when so far the transactions related to this were very, very low. So because of the fact that we are now digitalized, unlike in the earlier days when stockbrokers would essentially be running into the stock ring and shouting and screaming quotes in order to buy or sell stock, now it's all online. So the data is all there, and you have an appropriate algorithm. You can easily run through this particular stats and try to figure out if there's something mischievous happening there, right? Now, however, that's the probability of detection. But now comes the problem with respect to the probability of conviction. Now, even though I have detected someone, in order to convict them, I need concrete evidence to firstly, establish that this person did have price sensitive information. And this person was an insider. Now, here comes the definitional aspect. Now, SEBI's got all wound up in terms of these definitional aspects. Now, what is price sensitive information? Right? So unless you have a clear definition of price sensitive information, you're going to get yourself into legal quagmire and you can never get convicted. Right? Now, the second one is in terms of further establishing that this person had access to insider information. Now, in order to try and establish that this person had access to insider information, you need proof, right? What if this person were to say, well, I didn't have access to insider information. I'm just, risky trader. I love risks. and I'm just a penny stock chaser. I just chase stocks which are trading at 1 rupee or 50 paisa in order to try and get a phenomenal amount of money. If it succeeds, that's all I am. So why do you want to go after me? There are many other people like that. I just chose this and my luck worked. So it becomes very difficult unless SEBI gets concrete proof. Now, one of the ways in which the US has been very successful in trying to improve this probability of detection is by tapping phones. Is by able, and through this tapping of phones, they're able to access, messages, phone calls that are made between people who are privy to information, and therefore, through that particular methodology, they are able to establish um, that there has been, they're able to show good evidence that there has been access to insider information in this particular case, and therefore that insider information has led to this causal action of trading in insider transactions. Uh, so we are still stuck at that point. The probability of detection has increased, but the probability of conviction still is, you could say, pretty close to zero. All right. Most of them are still being challenged. Now, the other thing that has happened is SEBI has increased the penalties. So the penalties can go now up to 3 times the illicit gains. So it's a kind of disgorgement principle with a penalty over here. So if it's 3 times the gains, then what happens is that whatever you have, you've got to give 3 times that multiplied by the probability. So although the penalty has increased, the problem is that the joint probability of detection and conviction are still very, very low. All right. So we can have a discussion now if there are any questions before I go on to the next application.
So there's a lag in getting questions.
Okay, I'll wait. No problem.
Okay, so there's a question, and that is, why can't we have US model in India?
Sorry, I didn't hear that. Why can't we have?
Why can't we have the US model in India?
Oh, why can't we have the US model in India? Well, you know what's happening right now, right? The whole thing about the Pegasus, incursion into the phones of several people and phones being tapped, people being, surveillance of, different types of, non-compatible people is what's being alleged right now. uh, in a democratic society, trying to say that you want to have access to someone else's phone is a very sensitive situation. It's not going to be easy for you to get around that. Why is that the case? When you do want to access, when you do want to tap phones in order to ensure that conviction is greater, you need to have safeguards. You need to have China walls built so that there is no abuse of that particular information. Well, I'll tell you why it's still so dangerous over here, and why in our society we still fear our phones being tapped and information being, gained by some government agency. Let me point to the example of right to information activists. So, right to information activists. Um, they've been, if you go back to early 2000s, they've been very active filing RTA applications. And when they file for RTA applications in sensitive areas, or you could also say whistleblowers, even in the case of whistleblowers as well, their identity is supposed to be kept a secret. But yet, these people have been hunted down and killed by certain elements. Now, how is it that they have been detected when their identity should have been kept a secret? So in this particular case, the question that we have to ask is, what if the information that has been gained can be just used to blackmail you? So you see, that's the whole problem. So we need to have proper safeguards to ensure that even if you do tap phones, there must be clearly identified reasons uh, as to why and for what duration you need to tap a person's phone. and who has access to that information. So all of these have to be very, very clear, else it can just become a dangerous instrument. But otherwise, the general principles are all the same. We do look at the US system and we try to adopt as many good principles from the US. And we have a higher penalty system now, but there's a limit, as we already said, there's a limit to which you can increase penalties. Okay.
Thank you, sir. We have a question from Ms. Jyoti. It reads, sir, does this theory also make a case for legalizing gambling, taking into consideration similar detection and conviction rates?
Well, gambling, it depends on how you look at it. Firstly, whether gambling is rational. You might want to get into that because gambling itself can be quite addictive. And once it becomes addictive, then the question is whether you're making a rational decision at all. So normally the way in which state responds to acts which they view as being non-rational is that they act in a paternalistic way and they just decide to ban it. So that's the paternalistic approach. So look, you're not making a rational choice. And that's also, across universities, you have regulations, and all of these regulations are essentially sometimes paternalistic, which says that we don't think you're going to make a rational choice. So we're going to insist on these particular don'ts and do's. All right. So we're not going to say that this is going to be priced. Of course, there's always a price. You can convert it into a price, but we'll just say these are prohibited. So similarly, in the case of gambling, the state just says, sorry, no gambling. Similarly, yeah, but then markets evolve. They try to wriggle their way around these kinds of regulations, and they bring out these new ways of trying to get gambling into it. Why do they do that? Because they know people love to take a chance, and not everyone likes to take a chance, but there are different appetites for risk. So if you look at for instance, if you look at some of your e-wallets, they offer you rewards for carrying out transactions. And what are those rewards? Those rewards are not assured rewards. They say, you could win, this much, amounts ranging from this much to this much, if you engage in this transaction. So basically, they're trying to get you to engage in more and more transactions on their particular wallet, and you may or may not win a reward. And even if you do win a reward, inevitably it might be 2 or 3 rupees for every transaction. And what you would feel is, I lost nothing, but I did get a couple of rupees, so no big deal. So in fact, one of the questions that you could also ask related to that is whether these are anti-competitive acts. Whether Google paying these enormous amounts of discounts is actually forcing people to, with this instinct for gambling, to use its e-wallet more rather than other e-wallets. And as a consequence, is it preventing other new e-wallets from coming in? Because I would say, look, they're giving me money. I have a greater chance. So they're giving me discounts, so I'll go there, right? So therefore, there are ways in which firms are wriggling their way around these kinds of restrictions and introducing gambling in a different manner. All right. Okay. I hope that answers your question.
Thank you, sir. We have one more question for you, and that is from Mr. Ronald Jain.
Okay.
He's asking, sir, what kind of safeguards have been employed by SEBI to detect the practice of insider trading?
Shubhi, I think I lost you. You said what kinds of safeguards and
what kinds of safeguards have been employed by SEBI to detect the practice of insider trading? Moreover, what measures can be further taken by SEBI to increase the detection rate of insider trading?
Well, as you said, SEBI has taken a large number of steps, but where it gets stuck is in terms of conviction. Detection is easier now. All right. You can easily detect through software mechanisms because they're all online trades, they're all electronic trades. But However, it's the conviction. It is proving that they had insider information. It is proving that it was price sensitive information. That becomes the difficult part. And it is also establishing that they had access somehow from an insider. They got this information. So it is those processes where it's proving to be difficult. So the only way in which you can help SEBI is by allowing them access to concrete evidence which establishes that these people had access, got this information from someone who was inside, or they themselves were inside and they got access to this information. And of course, some of this is a part of clarifying the law, but it has taken a rather long period. When you say clarifying the law, part of this is also through a process where you approach the courts and you say, it says insider information and it says insider information which is price sensitive. Now, I'm not an insider. This information is not insider information. This is not price sensitive information. Now, if the law establishes very clearly who is an insider, what is insider information, and what is price sensitive information, and if SEBI also has in a very safe and secure manner access to the transcripts of phone records, well, all of this would actually substantially change the equation in favor of SEBI. Okay, Shubhi?
No more questions.
Okay, so one more application then. All right, so again, we can have a discussion over here. So the application is similarly with respect to heinous crimes, offenses against women. All right, so we have all these kinds of newspaper reports almost on a daily basis. Headlines screaming at us, which just talks about the dastardly acts of crimes against women. And as a consequence, it has created a strong response among a certain set of people who argue for capital punishment. And they say for any person who commits the offense of rape, that person must be hung. All right. So that is a sort of topic that we see a discussion around now. So capital punishment for rapists. So what does it mean? You can also ask a question whether such a person is rational. Are such crimes of passion, can they be fit into the mold of rationality? Certainly, we can still tackle these with the assumption of rationality, because if you do go by the kinds of studies that are done with respect to a profile of those people who have been convicted of rape, you find certain factors there which essentially speaks about the low probability of detection being one of the factors over there. And you could also say the low probability of conviction as well. So many of them are still under trials. All right. But anyhow, the point over here is that there's this whole discussion about having capital punishment as a single and one response for anyone who commits the offense of crime. Now, assuming, and with strong reasoning as well, assuming that a rapist is a rational criminal, would you, what kind of a law and economic reasoning, and when I say of law economic reasoning, I'm talking about the same approach that we had at the beginning when we said economics is a behavioral science. So economics studies how people behave under conditions of incentives and disincentives, assuming that they're rational and they would always like to maximize the benefits. How would they behave under a set of incentives or disincentives, right? And we said law essentially seeks to induce certain types of suitable behavior. So it seeks to induce certain types of suitable behavior by providing incentives or by providing disincentives. So now you use the economic method to analyze and see if these incentives and disincentives would lead to the desirable outcome. So now it's proposed that the law should be that you should have capital punishment. Now we use the law and economic approach to study and see, will this bring about the desirable consequences? So go ahead now, you're all in a position to give your opinion. what do you think is going to happen? How would you predict? What kind of an outcome would you predict? And in predicting your outcome, I'm sure you're going to inherently assume that the offender is rational. Okay. Comments. What do you think should happen? Capital punishment. Shubhi, we have some comments already.
No, sir. But yes, now we get it. Yes, so there is one comment by Mr. Dhruv. He's saying there is already a very high pendency. There would be enormous enforcement and punishment cost to give capital punishment to every rapist. And secondly, we have Mr. Sandeep saying not all offenders are rational. Is it, sir?
Yeah, you're absolutely right. Not all offenders need to be rational, and not all offenders are rational indeed, but most of them are. When we say most of them are, the question that we need to ask is how would they have reacted if they had known that, let me point it out in a simple manner. Well, when a person commits such a heinous offense, that person is obviously looking for a safe and secluded environment where the probability of being caught is very low. They don't do it in public. So in that sense, you already know that this person is behaving in a rational manner, trying to look at a scenario in which the probability of him being caught is very, very low. So there's rationality working there. All right. Now, and that's in most of the circumstances, right? So that's to answer your question as to whether we can assume rationality. I think we can safely assume that um, a large majority of them, a significant percentage of them, are actually rational. Okay. Well, there's a question if we can assume a rapist to be a rational person, why can we not assume a person who is a gambler or the consumer of an addictive good to be rational? I think they're two different things. Um, um, we need to get into the psychology of these two sets of people. We are not saying that someone is a habitual rapist by virtue of him becoming addictive to such an action. I don't think we have many such cases there. Here and there, of course, we do hear of some kind of a serial offender like this. And when there is a serial offender like this, we not only do put them into prison, but we also ensure that they get psychiatric treatment. All right. So we can't compare them. We don't say this heinous offenses against women can be passed off as a psychological disorder which requires a paternalistic treatment. But there was another question, Shubhi. I missed that question. You read out two questions simultaneously.
Yes, sir. The first question was, there is already a very high pendency. There would be enormous enforcement and punishment cost to give capital punishment to every rapist.
Yes, that's very true. Now, yes, one of the things is they say why we are not having sufficient amount of deterrence right now is because conviction rates are very, very low. All right. And when conviction rates are very low and many people are still under trials, and also when we have people being let off scot-free, when we feel in certain cases they should not have, we know that the probability is somehow lacking. The probability of conviction is somehow lacking. But even if you do convict them, well, there are enforcement costs in terms of prison spaces and so on and so forth. But then here, probably when you ask yourself the question, is the cost of enforcement worth it in terms of the benefit, in terms of sending out a strong signal to people who can commit such offenses, saying them that this is something that is not going to be acceptable? I think the benefit is substantially larger and is something worthwhile taking.
So we have a comment from Mr. Murtaza.
Yes, but
He is saying,
I'm still looking for a good predictive law in economics predictive proposition here. But anyhow, so what's that question, please?
it's actually a comment saying we cannot have punishment for murder and rape as same. It gives no incentive to the offender to not kill the person.
Excellent. Very good question. Now, the first thing that we say in law and economics is how do you predict that a rational person would behave when you propose this set of disincentives? So the disincentive that you're proposing is that this person should be hung till dead, right? Now, when you say this person should be hung till dead, and you say, look, the marginal cost of committing rape and the marginal cost of committing murder are both the same, then he will say, well, if I'm going to be hung till I'm dead for committing rape, and if I'm also going to be hung till I'm dead for killing someone, then there's no big difference. I might as well kill the victim, is what that person's going to think. And so the person goes ahead to kill that victim. So it becomes not just a heinous crime of rape, but it also becomes that of murder, because in that context, what happens is that this person reduces the possibility of being, convicted, as by killing the victim, the witness is eliminated, right? You reduce the chances of you being hauled up, right? Of course, there are forensics and all of that, but the extent to which do people go to after that is so horrifying. But this is the kind of prediction that you can make. Look, if you do get into capital punishment, and there's no difference, there's no marginal difference between the punishment for murder and for rape, then you can safely predict that this person is going to go the next step and commit this particular offense as well. That was a good response. Thank you. Any other comments, Shubi? Any other question?
We have one question, that is, under what constraint an offender is working if he is a rational being?
Under what constraints an offender is working? Well, here are the other things that we need to consider. All of these, when we consider a relationship between uh, legal changes and the outcome, we have to consider that legal changes by themselves will not work to produce a desired outcome. All right. Like, say, for instance, when we talk of the Competition Act and we talk about acts of cartelization, uh, one of the things that we discover is that there are many firms which still don't know that acts of cartels collusion are actually illegal. So similarly over here, what is also necessary to be emphasized is that, look, you need to be aware that if you commit this offense, you're going to be hauled up and put up for life. All right. Now that's the first thing. The second thing that you also need to be aware of is, look, you need to be aware that if you commit this offense, the probability of you getting caught is very, very high. Now that kind of information must be clearly sent across, and it must also be, concrete information, in the sense that it's not just noise, but it is concrete information which sends across a signal saying that this is definitely going to happen, right? So we have to account for socio-economic factors. When we look into the background of these people who have committed crimes, and we look at the socio-economic factors, then we are able to get a perspective as to what actually contributed to these people thinking that they could do this particular act and get away. And those are the factors which the law has to consider, rather than just simply increase the consequences. Not that we shouldn't increase the consequences, but it's just not going to have the impact. What is essential is that we should have the desired impact. That's what's crucial. Okay, Shubi?
Shubhi, please respond.
I think you probably lost Shubi. There's another question there. Time taken to go through litigation process, will that be a factor? Very good question, Jyoti. Uh, um, if it involves incarceration, the time taken to go through litigation process, when I say incarceration, I mean to say that if you're going to be an under trial who's going to be imprisoned, the way in which you factor that is going to be different from other crimes which do not involve criminal sanctions. So here's how I will mention this. Like, say, for instance, in the case of offenses which involve civil penalties, if the penalties that are going to be handed out to you involve an elongated period of time, endless period of litigation, challenge in this court, challenge in a higher court, and challenge in a further higher court, and then a reappeal and all of that. And let's say the entire process takes you about 10 to 15 years. Now, for a rational firm which commits an offense, if they factor in that if they do get caught, and if they do get detected, I mean, if they get detected, then the next thing is if they understand that there is a probability to get convicted, and even if they do get convicted, it's going to take place after 10 or 15 years, then what happens is that the present value of the penalty which they're going to pay after 15 years is going to be much, much lower. All right, so that's a time discounting factor that is operating. So if I have to pay, 10 million rupees after 15 years, it's going to be worth, probably 1/15 right now. All right. So therefore, the present value of the penalty that you're going to pay after 15 years is very, very low, and therefore it doesn't act as a deterrent. So delays in conviction, delays in the payment of penalties also reduce the deterrence effect. But in the case of criminal sanctions, if you're going to be in prison waiting for a trial, well, that's a different situation altogether. You may be proven innocent, but you have actually gone through a punishment already. Or if you're proven guilty, well, you're being punished throughout, and then finally you face the conviction. So that's a different situation than civil penalties. But these delays, the time taken in litigation, have a huge reducing effect on the efficacy of penalties. Shubi, any further questions or comments? There's one question there, it sort of disappeared. I don't know where. Okay. Okay. Shubi, I see some questions which are flashing, but they keep disappearing. I'm not able to quickly read them.
So you need to scroll it up and down. The same is happening with me.
Okay. So I need to scroll it up and down in all or my question and answers?
No, we are getting questions in Q&A as well and in chat box as well.
Okay.
So there is a question in question and answer part. I think I think we've answered that. If we assume a rapist to be a rational person, why can we?
Sure, that has been answered.
Yes, sir, that has been answered. Sir, we have a question. I mean, they're asking you to suggest readings on law and economics of crime and competition law.
Yeah. Okay. Well, there are many such resources. Probably I could type out some and send it across. That'll be helpful. But one good way to start is there is this online encyclopedia of law and economics, which you can utilize, which is a good comprehensive reading for law and economics. For competition law and economics, of course, there are several resources. I'll send across some resources by mail, which you can use. Or for
Sure, sir.
economic analysis of crime as well, certainly. You might also want to dig into behavioral approach to um, behavioral economics approach to crime. That should also be fascinating in case you assume a person is not rational.
Sure, sir. I'll be happy to send it across to all the
Okay.
participants.
So, any further questions or comments?
Professor,
Yeah.
would it be correct to say that when with regard to heinous crime against women, would it be correct to say that it is not the penalty? It's rather the other factors, like let's say the patriarchal, society,
Yes.
feudal mindset. Would those be, more
Yeah.
impactful?
You're absolutely right. So when we say socioeconomic factors, we notice some of these brazen crimes against women in particularly in settings which are very patriarchal, which are caste driven even, which even seem to justify such acts. So they seem to shroud themselves in these kinds of justifications on the basis of caste or on the basis of any other kind of patriarchal arguments, and egged on by certain sections of the limited society that they exist in. So that is another factor. These are the things which we also need to address, and not just increase the penalty. You're absolutely right.
Prof, do we have empirical studies on this that the magnitude of the impact?
There are actually, and I can send across a couple of them. There was one good study, in fact, done by NUS Delhi, some faculty there, and also some by our own faculty members here in NLS Bangalore. Well, I can send across some links to those studies. They were empirical studies actually. They were actually studies, which looked into the type of people who were convicted or who were under trials in the case of such offenses.
So is there some design in which we keep certain things status quo and just keep talking about the penalty to, get a very good public debate going on?
Yes, it looks like as if we're focusing on the low-hanging fruit, which really does not serve any benefit, and we're not looking at the substantial aspects which we really need to focus upon to change the mindset of men in these kinds of settings. And there are several other things. It's also about how we um, um, indoctrinate our children with respect to gender differences at the very young age, at the family level as well as at the school level. So these are the kinds of it's from these elementary levels that we got to bring about a change in the mindset as to how we need to treat women.
No, but Professor, with the entire paraphernalia going on, with the Criminal Amendment Act 2013 and all of that, and the number of rapes, I don't know what it was last.
The
Many
numbers are increasing actually.
in an hour. I
Statistics.
don't know. There's some horrendous figure of X in 1 hour.
Yeah. Now, in an empirical studies, if you look at empirical studies, which have been done for quite a few countries, there is no correlation. There is no uh, data which shows that an increase in the penalty for such kinds of crimes has actually led to a reduction in the number of crimes. Rather, the emphasis is more on the probability of detection and conviction, and also in terms of the socioeconomic factors which undergo change. So the empirical proof is out there. It's not just the penalty, but it's about ensuring that we address these other factors.
Thank you, Professor.
Thank you. All right. So, Shubhi, do we have any more questions? Any more comments?
No, sir, that would be it. Thank you so much, sir.
Okay, thank you very much. It was good to be with you all. Thank you for the wonderful questions. Thank you, Professor Anita.
Many thanks, Professor Somshekhar. Always, it is a huge learning experience. Yeah. See you again soon.
Yeah, bye-bye. Thank you.
Bye, Prof. Bye.
Afternoon, everyone. Our second session will begin in a while. We are waiting for Professor Santakumar to join the call. It will begin in a few minutes.
Ma'am, we are facing a little bit of technical issue with Shantakumar, sir. He will be joining us shortly.
All right. Please give the
Good afternoon, sir. Sir, can you hear me?
Okay, can you hear me now?
Yes, sir. Yes, sir.
Uh, good evening, Professor Santakumar. How are you?
I'm fine. Sorry for the mistake. I think there was some problem, no IT related problem.
No issues, sir. No issues.
Okay.
You're very welcome. Thank you.
Okay, so I will take, probably I don't have that much time now left, no? So it's already 4:20. So maybe I'll summarize in 20 minutes or 20 to 30 minutes what I have in my mind. Is that right? Hello?
Yes, sir. Yes, sir.
Okay. So I'm sure that most of the sessions that you had during this workshop would be about one or other research related issue, no? Probably a faculty may be doing some research related to law and economics, and they would have taken time to explain that research to you, introduce that research to you. However, I'm taking a slightly different route. The primary reason is that I'm not doing that kind of research now in the area of law and economics, because I'm interested. I'm doing work in a number of other domains, education and so on. But I thought that it may be useful if I describe to you my own experience with law and economics. Actually, I came to the subject of law and economics without any plan, without any kind of intention. It was an incidental encounter. After doing my PhD and after joining the Center for Development Studies in Trivandrum, I was working mostly on issues related to environment. So environmental economics was my sort of main domain at that point of time. But while working on environment economics, we encounter a number of issues. One important issue was the public interest litigations. For example, if you know about environment or environmental agitations, environmental control in different parts of India, in most cases, you can see that the court or the pollution control board acts whenever there is a public interest litigation. So public interest litigation became an important instrument for environment management in India. And then I think I got some exposure and I wrote a paper on public interest litigation. Of course, it is through that I got an exposure to the world of law and economics. And then I had an opportunity to be a postdoctoral fellow in a US university, where there was a professor who was introducing me to the law and economics. So why did I say this? No, because when you actually do work on a number of issues in India, you may encounter institutions or institutional failures, and that may sort of lead you to law and economics. Of course, then I started working on a number of institutional issues. Of course, at some point of time, I also wrote a book on law and economics with senior colleague, Shubhashish. There was also a book on economic analysis of institutions and so on. So I would say that I had some exposure to law and economics through this particular route. While working on law and economics, I realized something else. That's what I'm going to focus today. If you look at, there is some difference between core economics research and, I would say, an interest in law and economics. I'm not calling a research in law and economics, but an interest in law and economics. let me talk about a typical economics researcher in India, or maybe I'm talking initially from the world, no? Somebody who is doing well in an international university. His or her work usually involve, of course, now he probably the first step in any economics research is to come out with a testable hypothesis, and that require a derivation of hypothesis in a logically consistent manner, and mathematics is actually used. So economic theory, the mathematics or mathematically oriented economic theory is used to derive these hypotheses. And then there would be a testing based on an elaborate testing of these hypotheses by putting together whatever data that is available. So that is the content of a typical economics research. When you are actually thinking about an average or a conventional researcher in India, mostly it will be data driven. These days, people are quite proficient in statistical analysis. They know how to use computers, so it will be a data driven research. In most cases, they may use hypothesis derived by somebody else, which is available in the literature. So they may use an existing theory and do a testing in the Indian context with whatever data that is available in India. So that is the job, no? That is the kind of work pattern of a typical economist in India. Of course, now many economists in India are also not that interested in looking at theory because they may have different ideas about theory. They may not be following neoclassical economics, so they may have their own theoretical ideas or insights. So they may not be even thinking about developing that derivation of the hypothesis in a logically consistent manner. So they may start with some kind of ideas, some kind of hypothesis. I think this is fine. But there's a big problem that I see, especially among Indian economists. See, whenever there is a social issue, there are a number of social issues around us. No? For example, dowry could be an important social issue. I'm sure that now some of you are already talking about rape. Not only rape, but whenever there is a rape, people talk about the importance of death penalty. That could be another issue. Child labor, continues to be an important issue. So we encounter on a day-to-day basis. I think any social scientist, any close observer of Indian society encounter a number of social issues. And in many of these social issues, we may not have time to collect data. There may not be enough data. For example, it is very difficult to talk about whether death penalty will reduce the rape cases in India. It's very difficult to collect data on such an issue. Similarly, we have right to education, but still that the enrollment is, of course, enrollment is high, but dropout rate continues to be high. Even in Gujarat, probably 20% of the girls drop out in secondary grades. Right to Information Act, we have an act, but no, only very few people actually use the Right to Information Act. So if you actually analyze it now, there are a number of social issues of that kind. So that is one point. Secondly, of course, we may think that these social issues are not in our domain. They're not in the domain of economics because it should be in the domain of sociologists and so on. That's not true. If you actually analyze some of the core issues of economy, for example, everybody recognize that the slow growth of manufacturing is an important challenge in India because that is creating what is called the jobless growth. That's creating the slow pace of employment growth, and that is leading to the persistence of poverty and underdevelopment in India. So what is preventing the growth of manufacturing in India? Of course, no. Now we are by and large an open economy, and one set of people will say that no, that's because of the rigid rules, no, the labor codes, lack of labor reforms, etc. Other set of people, people like me, would say that you look at your labor supply, where only 18 to 20% of the adult females are taking up paid employment. Why is it so? Because of the gender norms. So the point is that even when you look at the core economic issues in India, quite a lot of these are actually connected with institutional problems. And some of these institutional problems, whether it is child labor, whether it is dropping out of girls in secondary grades, or very low work participation rate of females, which also have something to do, I mean, which also impacts the economic growth, employment growth, etc., etc. These are also social and institutional and normative issues. So you cannot separate the economic issues from institutional and social issues in India. I mean, that's nothing, it's something obvious, because now in a relatively underdeveloped economy, which is facing structural problems, some of the barriers, some of the major constraints that we face in economy are also due to social and institutional issues. Even if it is due to the rigid labor laws, now that's also an institutional issue. So I'm not talking about sorry, just one second. I'm not talking about the other kinds of social issues. So even if we are interested in economy, we are confronting a number of social and institutional issues. Okay. So in the life of an economist or an economics faculty, I presume that some of you who are attending these lectures are researchers or teachers in colleges. We encounter a number of these issues on a day-to-day basis. It could be, when you are in the classroom, a good student may be asking a question, or maybe the newspaper may ask you a comment, or when we actually do research, we will confront some of these issues. So we cannot neglect, we cannot overlook this particular issue. But no, the problem is that now let us take this to what I have said earlier. No, earlier I told you that we are trained to do research, mostly data driven, or if we are probably good at the economic theory, then some of you must be deriving hypothesis in a systematic, logically consistent way with the help of maths. And then you are doing the data-based testing of these hypotheses. It takes time, and it takes a lot of, probably some of you may be writing one paper per year, even that is a very good achievement, or probably quite a lot of people may be taking 1 or 2 years to write a paper of this kind. But no, that means suppose that such a person is taking class in BA or MA, and every day he or she has to confront a number of social issues. So this is not sufficient. If your economic methodology or tool is enabling you to analyze only one social issue per 2 years, or one per year, that's not sufficient. We should have a tool to analyze. We should have a tool to analyze a number of social issues that crop up on a daily basis. We should be able to develop some kind of reflective commentaries on this issue. For example, when there is a rape incident in your city, and people may ask you this question, well, what can be done? So when you say that, no, we should have a death penalty, or we should have strict law, I'm sure that are you giving that answer from your moral perspective? Are you giving that answer based on some knowledge of economics or some understanding of economics? When you see child labor, or children not going to school, or when there is corruption, all these are institutional things around you. When there is a discussion of this kind in the classroom or elsewhere, people give opinions. No, there are opinions, but no, are these opinions based on our own moral perspective, our own individual kind of ideas, or is there some economic tool or methodology informing our opinion? I don't want to take this too much, but I just want to summarize and tell you that if you are getting exposed to law and economics, that is a very good way to capacitate you to develop informed commentaries on social issues or institutional issues that we face on a daily basis. I think I have gained a lot by studying law and economics in that sense. When I think I'll just talk a little bit about my own biography, or not biography, my own work. Not necessarily to talk to you about I think I don't want to give you an impression that I've done some work. That's not the point. But essentially to motivate you that you can also use law and economics for that kind of purposes. When I was actually teaching or doing research in a conventional research institute, but then I joined a university where the focus is to create development practitioners. For example, people who are taking up jobs in non-governmental organizations, in health or education, livelihood, and other kinds of spheres. These people are problem solvers. No, they have to address issues of poverty, problems of ill health, or underachievements in education, and so on. So these people are going to use whatever knowledge that they have in solving their problems. So can they use economics? Of course, no. If we want them to use economics, they should have a tool that they can use it on a daily basis, not by doing research which takes 1 year or 2 years. So somehow I think my exposure to law and economics enabled me to create a kind of, I would call a teaching package, which is also available in the form of a book, to enable these practitioners to use the tool of economics to not only to understand, but also to address some of these day-to-day economic or social issues. I think I've also tried this in several other platforms. One, of course, I don't want to do a marketing, but one or two platforms is, I think is worth mentioning. For example, if some of you are really interested in connecting economics to real world issues, some of these platforms are useful. One, I think there is a kind of a, there is a platform, there is a blog which is titled Economics in Action. So there is one essay per week picking up a social issue, but it is analyzed with the lens of economics. And I think in doing that analysis, law and economics was really helpful. Similarly, there is another platform, because now quite a lot of our teaching in BA and MA classes are very theoretical, and the student in a BA class, if you take 90% of the students in a BA class, actually they are not going to be economists. They go to become a clerk in a bank or in a private company, or maybe a government official, or may start his or her own business. So what is the microeconomics that you can teach such a student so that he or she can take the core insights of economics to his daily life? No? Again, I would say that if you're thinking along those lines, law and economics would be very useful. So there is a platform which is called Real Life Microeconomics, and that helps you to connect some of these, connect the methodology of the tool of economics to some of the real world problems. I think I'll stop here, and I think I'll leave the whatever time that is remaining for you to. I mean, I'm just using this as a challenge. For example, there may be some issue that you may have encountered. It need not be directly economic. Some issue that you may have seen around you. You may have read it in today's or yesterday's or other kinds of newspaper, and you can pose it as an issue. No? Can we use law and economics to understand? Can we use economics to understand it? Can we develop a commentary of that issue in, say, 10 minutes or 15 minutes? So I'm posing it as a challenge. So if you can pick up some of those issues, we can jointly try to develop a commentary of that issue. I know that whatever I have said may not be that useful to those who are doing PhD and interested in doing research on law and economics. That is fine. I'm sure that you have 99% of the faculty would be focusing on that aspect. But those who are interested in this different dimension, I think it is interesting to spend some time on that. Thank you. Thank you very much.
So there's a slight lag in our chat box. So meanwhile, you can maybe take up this question that has come up for you. I'll read it out, sir. Ms. Jyoti Chindal is asking you, sir, I'm doing a paper on legalization of cannabis in India. What particular economic tool or concept do you suggest for it?
Okay. One particular issue is, see, again, I think I would say that we should be thinking about some India-specific challenge. No? That is something very interesting. Because legalization, when you're talking about legalization in the US or in some of the developed countries like Switzerland, you know that there is also, they have a policy of distributing drugs at specific doses to drug addicts. So they have a fairly elaborate policy on that. So can you think about an India-specific or a developing country-specific challenge for the legalization? Okay, let me highlight. I think I'm not getting into this particular issue, but I will try to tell you something from another case. I think then you can connect it easily. I'm giving you that intellectual space for using your own creativity. That is why I'm not using legalization of this as a specific example. For example, if you actually look at ecological economics, there is no reason to ban hunting of wild animals. Hunting of wild animals is not necessary because actually many developed countries have provisions to hunt animals, hunt wild animals. Actually, hunting is good for ecology. If you don't know, I can explain it later. But no, many countries have a perfect ban or a complete ban on hunting. Why should that be the case? One problem is a problem due to the enforcement issue. So there is an enforcement burden. The cost of enforcement is very high. So when enforcement is imperfect, a controlled hunting or allowing hunting in a regulated manner cannot be enforced. When you cannot enforce control hunting, the problem is that there will be a lot of hunting going on and it will be difficult to know whether it is controlled hunting is or illegal hunting. And there are a lot of information asymmetry issues there. And because of that, you cannot actually enforce a controlled hunting. So that means the cost of controlled hunting could be much higher. And one way to reduce the enforcement cost is to go for a complete ban. So in one sense, you can see a number of cases where theoretically a uh, regulated use is better. However, the cost of enforcement is very high, and that may encourage policymakers to go for a lot more rigid or strict policy, which could even be a complete ban on a particular practice or an action. I think this could be one way to think about it, and there are definitely interesting ways. There could be other interesting ways. Yes.
So we have not received any.
Oh, that's perfectly fine. Yeah, that's perfectly fine. I think I could finish it in my limited time. So if there are no questions, I think we can stop it here. Okay.
All right, Professor.
Yes.
Sorry for the, we had very short time for the interaction, but I'm sure we'll be having better technical situations and have a more elaborate, detailed discussion on another academic program.
Okay.
Thank you, Professor. Thank you.
We will be starting our next session in a few minutes. It will be taken by Professor Anurag K. Agarwal. We are just waiting for him to join the meeting.
Good afternoon, Professor Agarwal. We'll be starting your session shortly in 4 minutes. Hello, am I audible?
Yes, you're audible, Shubhi.
Good afternoon, Professor Agarwal. Thank you for joining us today. We'll be starting a session now if you're ready, please.
Good evening.
Good
Are you
evening,
able to hear me?
Professor. How are you?
I'm very well. Thank you. Thank you, Dr. Nagar. How are you? Am I audible?
Yes, yes, you're audible.
And can you see me clearly?
Yes,
Okay.
we
Okay.
can.
Very good. Very good.
We are so far all right.
Very good. So I will.
Pratyusha, can you please introduce her before we start this session?
Good evening, everyone. Today, our third session of the day will be taken by Professor Anurag K. Agarwal. He is a professor at the Indian Institute of Management, Ahmedabad. He has been the first recipient of the Marti Manaria Gurunath Outstanding Teacher Award, and his teaching, consulting, and research interests include business leadership, negotiation, strategy and law, infrastructure and PPPs, contracts and arbitration, banking, intellectual property, medical legal issues in healthcare, and related issues. He is also a visiting faculty at National Judicial Academy, Bhopal, Gujarat State Judicial Academy, Ahmedabad, Gujarat National Law University, and ESSEC, Paris. Today, in his session, he will be discussing on patents, the legal and economic perspective. Over to you, sir.
Thank you very much. Thank you. So I would like it to be as interactive as possible. So please feel free to ask any question, any comments in between. The participants can ask me or any of the other panelists. So let me just. So when we talk about patents, so the first thing is to talk about intellectual property. And talking about intellectual property, the first thing we would like to talk about is property. Now, property, the concept of property is interrelated with that of ownership. And it has been found extremely difficult by legal thinkers, jurists, and legal philosophers to define property. So they say that we would like to understand property in conjunction with ownership. So broadly speaking, it is said that anything which is capable of ownership can be said to be property. Very interesting idea. And there are three essential features of property. And these are Latin phrases: possidendi, that is the right to possess; utendi, the right to use; and dispodendi is the right to dispose of something. Now, property simpliciter, when we say any property, which means that it is tangible. It may be movable or immovable. Movable like this mobile phone, or immovable like a land, building. And we can call it tangible property. Now, intellectual property, the difference is that tangible property is composed of atoms. It is a physical thing, and it can occupy only one place at a given time. So for example, this mobile phone, if I keep it here, it is only at this place. It cannot be at two places at the same time. So possession is exclusive. So if a student has got a pen and he gives the pen to B, then A doesn't have the pen, only B has. So possession is exclusive. If A has it, B does not have it. So that is the concept of excludability in any tangible property. But when we talk about intellectual property, so intellectual property does not have the characteristic of excludability. So for example, if A tells B an idea, now A is not deprived of that idea. A also knows and B also knows. Now B tells to C, so A, B, C, all of them know about it. C tells to D, A, B, C, D, all of them know about it. And D takes out his smartphone and sends a WhatsApp message or on a group message, so everyone gets to know about it. So A and B both possess it. So in that sense, possession and use is non-rivalrous. Both A, B, C, and others can also use it. So possession and use is non-rivalrous in case of intellectual property. And that is one of the biggest contentious issues. It is one of the great characteristics of intellectual property, but it creates problems also. Now the issue arises, particularly for businesses and all, that there are certain basic intellectual property rights. So you need to secure them. So what are those main basic intellectual property rights? The big five, as we call them. So patents, know-how and trade secrets, designs, trademarks, and copyright. So these are the big five. The difference between know-how and trade secret. So trade secret is completely sort of a secret within a company or a group of individuals who know about it. Know-how is something of practical relevance of how you do it. So very, very practical things. Then there are geographical indications, which, for example, like basmati rice and Darjeeling tea and Scotch or champagne. These are all geographical indications. And then there are layout design of integrated circuits, which are also intellectual property rights. But the main big five for most of the businesses are patents, know-how, trade secret, design, trademarks, and copyright. Now, when we are talking about intellectual property, just a little bit about TRIPS, that is the Agreement on Trade Related Aspects of Intellectual Property Rights. TRIPS, which is a part of the World Trade Organization, WTO, and it was established in 1995. So TRIPS is that global treaty, the agreement which governs for all the members the trade related aspects of the intellectual property rights. Now, whosoever are the members, they are under an obligation to provide minimum IPR protection. So whatever the minimum IPR protection has been decided by different members and according to the TRIPS agreement, that has to be provided. Now, after that, they have to ensure effective enforcement of these rights. Whatever is the enforcement domestically by their national courts or tribunals or other adjudicatory forum, it has to be done by them. After that, they agree to submit any disputes to WTO dispute settlement system for anything, any dispute related to the TRIPS agreement. Now, let's move on to patents, which we are going to talk about today. And you keep hearing about patents very often, particularly during these times. So patents, you can say, are legal rights which are granted for new inventions. These are legal rights. Now, remember, the patents are not natural rights. These are not granted by the God Almighty. These are not some natural, like human rights, you can say, just because we are human beings, so we have a right, which are, you can say, as human rights. But patents are not those rights. Patent rights are legal rights which are granted by, according to a statute, according to the law. And in fact, these are what's said, not positive rights, but these are negative rights. Negative rights means the inventor is not granted a right that you can do something. In fact, others are stopped from doing any such thing. So these are negative rights. So for example, if there is a park and everyone can go, it's a public park and everyone can go to that park. Now there is no problem with that. But one day, one person takes the ownership of that park and only that person says that he can go in. Others are not allowed to enter. So in fact, others have been stopped from entering. So it becomes a negative right in that sense. So, but patents are legal rights. And in the absence of a statute or a patent law in a particular country, you can say there may be no patent right. So patents come with the law. If law is not there for a patent in a particular country, in a particular jurisdiction, there will be no patent right. Usually it is given for a new and useful article, improvement of an existing article, something which is already existing. Some improvement has been done to that. So a patent can be granted for that. Or it can be a new process of making an article. So something is already being made. So you make the process better and then try to make it in a different manner. So there is that, you can say, the tension, the distinction at least. And earlier there was this two different things of something called product patent and process patents. So product will be for a product, as the name says, for some article, for let's say a molecule, for an engine or any machine. But the process is the process of making that. So if you make a molecule by adding A and B, So that is a method of making A plus B and you get the molecule C. But if someone comes up with a new method, a new process and says, instead of A plus B, we are going to make it A1 plus B1 under different conditions. Conditions 1. So you get the same product C, but now the process is different. So you get another patent for that, the process patent. And that was the crux. You can say since 1970, when the patent law in India came, there was a major change at that time, particularly for pharmaceutical patents. Excuse me, just. So the process can be different for the same product. And that was an issue for the multinational pharmaceutical companies, which wanted to have a product patent that by different processes you cannot make, even by different processes. And that change was brought into 2005 with the amendments in the Patent Act of 1970. So that is one of the major changes, and you can say one of the facilitators of having a big pharmaceutical sector in India. Large number of companies in India, and their expertise was particularly said to be uh, of reverse engineering. Take a molecule from abroad, from a multinational corporation, work on it through a different method, and make maybe very cheap versions, even generics in India, and you can even export them. So that was what was happening. So that was stopped with the TRIPS agreement in 95, and which gave us a 10-year window to change our laws and switch over completely to product patents. Now, a few more things. The term of a patent is 20 years. Now, patent is something interesting in the sense that the inventor and the patent holder gets monopolistic rights, but these are temporary, not forever. So, and this term period is 20 years. Earlier in India, it was 14 years for pharmaceuticals, but it was all changed after the TRIPS agreement and brought uniformly, homogeneously, harmonized to 20 years for almost all the TRIP members. So now the term is 20 years, which is a fairly long period of time, typically for pharmaceutical patents, because companies get into different sort of tactics to get it extended beyond 20 years. So this is very contentious, highly contentious, disputable. And there are a number of issues involved with this. So there are legal issues involved. There are economic issues, ethical issues. Ethical issues, of course, you say, it's my human right to get a medicine in case I'm sick. But the company having the patent for that says you need to pay this much price. And there comes the role of pricing. So you need to pay this much. But as a patient, I say, I don't have the money, but this is my human right. This is very unethical for you not to give me the medicine. And this is the tension between these two things of patent rights on one hand and the human rights on the other hand. And there are pricing issues, as we were talking about, with temporary monopolistic rights. Of course, you have the right to control the market, and thereby the prices go up. Then there are health issues related to pharmaceutical patents. The law in the country is Patents Act of 1970, amended in 2005, and different amendments at different points in time. But major amendments have been in 2005 and earlier a little bit in 1999. Now, patents are said to be the creation of intellect, creation of mind. So you work, you come up with certain idea, and you try to work on it. But there is a problem. And the problem is that you yourself cannot get something patented. That unlike copyright, which is very interesting, that you create something, you write an article, you create a song, you make a picture, or a painting, or you capture a picture through a camera, and you immediately get a copyright on it. You need not go anywhere to get it registered. But for a patent, that's not the case. You do not get the patent immediately, and you yourself cannot grant a patent to you because you have to go and apply to the patent office. Patent office in different jurisdictions, whether in India, Japan, United States, European Union, and other places, a number of things are quite common, but then there will be differences. And these differences are at times very well in black and white, but there are interpretations, and discretionary power is used by the patent office. The examiners, the officers, the other staff, they use their discretionary power whether a patent can be granted or not. So it is quite possible that for the same invention, the inventor may get a patent in country, or let's say office A, but not in office B. And that has been the case or a grouse of some of the multinational pharmaceutical companies typically, that Indian patent office in India is quite strict uh, as compared to the patent offices, especially in the United States and even in the European Union, which are quite liberal, quite lenient. So for a number of things, patent office in the US, which is called USPTO, because United States Patent and Trademark Office, it's all combined together. So it's quite liberal, and a number of patents are granted, which will never ever be granted in India. So that happens. But creation of intellect, so one thing is clear, that you cannot get a patent yourself. And second, you cannot get a patent for an idea. No, ideas cannot be patented. So if you have an idea, you need to work on it. You need to make a prototype of whatever idea is there in your mind, and you need to make something. So the first quality, the first characteristic feature which should be there in a patent is that it should be novel. There should be some novelty. Novelty means something new. So you cannot get today, you cannot make a wheel today and get it patented, of course. And that's why the phrase reinventing the wheel. There is no point. So you need to come up with something new, which is not known. The question arises, not known where. So the thing is, not known anywhere. It is not as if you are living in a country, for example, United States. And earlier it used to happen quite often that some researchers and others would be visiting India. India, uh, continental sized country, 5,000-year-old civilization. In every nook and corner, there are so many things they get to understand. And they will pick up something, go back to the United States, work on it in the laboratory, and then come up with a small molecule and say, this is something new which we have created. And the patent office in the US would never ever have known what is maybe so very common in some of the areas in India. Just for example, and these have been long intellectual property battles which India has fought. In India, that neem twig, datul, is so very common for brushing and cleaning your teeth. Now, they took the neem abroad to the West, and with the neem molecule, they wanted to patent that. They have been quite successful in doing all these things, whether it's for turmeric or neem or ginger or several other things. Even for the rice, basmati rice, which is a geographical indication, but problems arose. So India had to fight a long legal battle, particularly using the same law which was there according to the TRIPS. So it should be novel. And now to take care of all these problems, what is being done is we are living in the age of internet. So everything is connected with database and all. So there are search engines specialized for patents and all, and they will give you a search report that whether there is something like this already available or not. Second is it should be non-obvious. Non-obvious means that it should not be something so very obvious to a person who is working in that field. So if you say, just for example, that you want to dilute milk. A person says, I have come up with a new method. So first you take a jar, you pour milk, and then you add water. So milk is diluted. The second person says, fantastic, wonderful, but I have got another method. He says, what is that method? So you take another jar, first you pour water and then milk. The third says, I have another method. You take 3 jars, one empty, and in 2 jars, one jar with milk, one with water, and you pour both milk and water in the third empty jar. And this is the third method. You say, what nonsense is going on? This is all very, very obvious. You cannot get a patent for this. So this was some extreme, but for some of, you can say, these type of things, not exactly is so simple, but you can find that US Patent and Trademark Office has granted a few patents. And that's why it would be interesting for you to just do a little bit of search on Google and find out the most ridiculous patents which have ever been granted by the USPTO. You'll enjoy reading them. Now, utility. They say whatever is going to be patented or applied for a patent, it must be useful. There should be some utility. You cannot make a machine and say, I want a patent for this, but then someone asks you, what is this machine? What does it do? You say, this is just a machine. I don't know what does it do. No, it should be, there must be some use of that. You come up with a new molecule, but you say, I've just made a new molecule, but I don't know what is the use of this molecule. So for example, this post-it, the post-it, if you read about it, the quality of a post-it is that uh, these the edge which pastes very simply, and if you remove it, it doesn't leave any smudge, no marks on that. So in fact, when people were working on it, so they got a lump of some glue, and the inventor was very unhappy with himself because he was working on an adhesive which should be very strong. But instead, he got some glue which won't stick anywhere. So, of course, you can't do anything with that. But later on, he and others came up with this idea that this particular glue can be used as post-it. Now, that is a patent, and that becomes something very, very important commercially. Enablement. While making an application for patent and all, you must enable the person in the same field who can really make the patent. And patent means you are going to the patent office and declaring everything, right? Specifications, drawings, how you did that, and how others can do it. So it doesn't remain a secret. It is there in public domain. Anyone can watch it, anyone can read it, anyone can understand it. Earlier, pre-internet days and all, one has to go to the patent office to look at a particular file. But nowadays, it's very easy. If you want to look at the recent patent, let us say, latest patent of Apple or Amazon or Google, you can just put it on Google itself and say latest patent, Amazon and USPTO, and it will come right on your screen in less than 10 seconds. Everything on your screen with details, specifications, drawings, how to do that. Everything will be there and very, very clear. So enable. Now, when you want to protect an idea, which of course you have enabled, made a prototype, made a real something, it's just not an idea because you cannot protect an idea. You have to convert it into some sort of a machine or some sort of a equipment, apparatus, something, only then you can protect it. Now, this protecting an idea has got social benefits and social costs. So what can be the social benefits? Now, patents encourage innovation. So if you are talking about patents, and until unless the inventor gets something in return, so how can the society reward the inventor? You say, okay, we are giving you monopolistic rights, temporary for 20 years. Only you can make it. or you can license it to others, you can assign it to others, you can sell it to others, but it is your property. Only you can do that. No one else can do that. Very good. So at least you have monopolistic rights. So it encourages innovation in that sense. And by when you encourage innovation, you get better, newer products, new methods, which are typically better. You keep on working on better products, better methods, and better, and better, and better. So who would have thought, let's say 10 years ago, that in this type of a smartphone, you can have everything in your hand? I remember around 20 years ago, when there was this advertisement by Reliance at that time, not Geo, but Reliance, about the mobile phone they brought in the market. And their tagline was, Karlo Duniya Muthi Mein, Karlo Duniya Muthi Mein. So today, of course, almost your entire world is in your hand when you are holding this mobile phone. No one could have ever thought about it. Better and better and better and better. I'm having a bottle here, and uh, this is the cap of the bottle, and these are the threads. Engineers must be understanding that the threading part, and when you turn it and again. So some of the bottles, you need to turn the cap several times. Only then it fits in properly. Some of the other bottles, the cap you need to turn only half, and it will be as good as. But I invert the bottle, it's half full with water. But if you keep watching, not even a single drop is oozing out. Now, this is because of a better cap. If you pick up a bottle of any mineral water, any drinking water, what you will find is it has almost all the different features of intellectual property. Patent you can find in the cap, the design, the shape of the bottle, the design. Copyright is the entire logo, entire arrangement of the label and other things, the way it has been done. Trademark is the name of that name and the logo, what is known as in law, device of that bottle. For example, Aquafina or Kille or Bisleri or by whatever name. So new product or new method, and this is particularly important in today's world when you talk about pharmaceuticals, vaccines, and other things. So you are asking about a new, better thing. It can be cheaper and or better. So cheaper and better. That is what the world is asking for. Again, some of the good examples again are of mobile phone, uh, computers, laptops, televisions, and so on and so forth. So things are very cheap when you compare them, of course, with the value of money over a period of time. These are definitely far cheaper. An electric bulb, for example, 150 years ago, Thomas Alva Edison came up with that bulb. They invented the bulb. At that time, only you can say filthy rich people can afford to have an electric bulb. But today, forget about the electric bulb. After that, so many things. The incandescent bulb and the fluorescent tube light and then the CFL and LED, so many things have come up. So cheaper and better. These are all the social benefits, what you get from patents. Examples, as I was just talking about, pharmaceuticals, automobiles. Automobiles, again, the way the engines are functioning, the way you are trying to make the best use of even a drop of fuel, whether petrol or diesel or now electric vehicles, machines, such better performing machines, better methods. Methods can be fantastically better and better, which were used earlier. And some of these are patented also. Now, in the present scenario, again, as I was mentioning, present scenario of COVID-19 pandemic, vaccines which have been made by different companies. So whether it is Pfizer, whether it is Moderna, whether it is Johnson & Johnson, whether Covishield, AstraZeneca, whether it is Covaxin or Sputnik, there are different vaccines using maybe a different ideas, thought processes, and different patents they may. Most of them have applied for different patents, but because things are moving so fast that right now 20 years time period for a vaccine, uh, people are not waiting for. 20 years is a very, very long period of time as far as the pandemic is concerned. We are talking about 20 months or 20 months or rather 20 days. What's going to happen in the next 20 days? Another 20, another 20. So that is, instead of talking about such long periods of a period of time. Then when we talk about patents, it's not only social benefits, because uh, both things come together hand in hand. Social benefits, social cost. Same coin, two sides. You cannot have only one. So there are social costs also. And what are the social costs? As we were talking about, this is a monopoly. Patent rights are monopoly rights, though temporary. Though temporary, this is not a permanent monopolistic right or monopoly. These are temporary. So when you have a temporary monopoly, what does it mean? Higher profits, particularly during that period of time. So how will you get that? You have control over the quantity because only you are able to make it by law. Law permits only you to make, distribute, sell everything. So you control the quality, quantity. So I'll make only this much and nothing more than that. Now, that has typically been a problem with the multinational corporations, pharmaceutical companies in the West. I remember like in 2001, there was anthrax scare in the United States immediately after 9/11. Anthrax scare was that a white powdery substance was being posted in letters. And this was the anthrax powder. They said it will spread and contagious and all such things. So for that you needed ciprofloxacin, and Cipro was being manufactured by Bayer, the German company. And the German company was very, very clear about it that we cannot produce large quantities. We can only produce this much, not beyond that. And German law, labor law, and all, if you know about it, it's very, very stringent. Even if you need to make workers work overtime or even on the weekend, a special permission has to be taken from the government. So it was not easy for Bayer to get more quantity produced. That is okay, let's work 24/7 and produce too much. No, no, they said we cannot. But at that time, remember 2001, so product patents, the law had not changed in India at that time because it changed in 2005. So a number of companies in India, some of them had already reverse engineered it, and Cipro was available as a generic medicine in large quantities at very, very low price. Basic principle of economics: higher the quantity, low the price, demand, supply, and all such things. So high quantity, any quantity you like. And the Indian companies said to the United States and others, you can take as much as you like from us. But then, of course, it would be through generic and reverse engineering, So somehow United States said, okay, we'll try to manage with Bayer and others, and didn't take it from us. But the basic issue remains that there are social costs of patents. Currently, we are facing that same issue with vaccines. There are negotiations going on with Pfizer and other companies, Johnson and Johnson. When these companies want indemnity from India, and also they want a guarantee for this much of quantity of supply. In fact, that is what India wants. India says, because it's a huge country, 1.3 billion people, so we need an assurance from you that you will be able to supply this much quantity. For that, the companies want that you should waive off a number of things. Particularly, they want indemnity for any losses and any lawsuits later on. So this is one of the social costs. Then because of these reasons, the society is deprived of these products and services, which could have been easily available at low price and in adequate quantity had there been no patent. So patents create this problem, which is a social cost. Now, what happens is once the term of the patent ends, that is 20 years, that term ends, the price falls and the quantity increases because others start making that. Now, how can the others make it? Now, see, they are competitors and the details are already available with the patent office. So they very well know how to make it. There is no problem with them. But the law does not permit them to make anything before 20 years. So their hands are tied. So they have to wait for some time. And only after that they can make it. So immediately at the end of the term, the market is flooded with the products and the price falls and the quantity which is available increases. So that is one of the interesting things which happens. Now see, when you are in business, especially the pharmaceutical companies, they don't like this idea that after 20 years, the term is getting over and everyone will be making it. So they try to make some changes, new changes, and we were talking about novelty in patents. So they make certain changes and try to come up with a new substance, so-called new substance. Though practically, for all practical purposes, it is the same thing. But they try to make some changes and go to the patent office again and say, this is something new, some new change here, there, in the process or this and that, and grant me another patent. Now that becomes an extension, you can say, for another 20 years. And after that, another, after that, another. And this process is called evergreening. Evergreening. You keep on sort of renewing, which is not allowed by law, but you make those changes. And if the patent officers are quite lenient, they say, yes, this change is patentable and we will grant it. That has been again a problem in India. And that section is section 3D of the Indian Patents Act, where the patent office in India and the courts are of the view that basically they're saying, no, we have to be quite strict about it. We cannot allow such extensions, patents to be going on continuously or perpetually. So that is not a good thing. So evergreening is one method which they use. Some different companies, there are other terms used which are called ticketing, from the ticketing. So you get a number of patents and then there are layers of patents. For the same product, there may be one here, one here, one here, one here. So one is expiring now, the other is expiring after 2 years, another after 3 years, another after 4. So in this way, if you want to make that one product for 10 different components, the patents still keep on existing, and you find that you are unable to make the product. So ticketing can be there. Another is called blanketing, where blanket, just like the blanket ban or some bombarding or anything, you just go ahead and get patents for almost everything near to that and related to that. So these are those social costs which are imposed on the society in that sense. But see, in high-tech industries, very high technology industries, you don't need that. These are sort of natural monopolies because the technology is at that level where others are not able to match it. There may be hardly any competitor. There are entry barriers and they may not be able to even make it, even given a chance. So it becomes a natural monopoly. For a few companies currently making vaccines, this is being said that even if we allow you to make it, even if we allow you to make it, you won't be able to make it because you don't have the capability. You cannot. It will, even if to create that capability, capability building, you need at least 6 months or a year's time, at least, even if you have all other infrastructure, you have the manpower, trained manpower as we have in India, but still you have the biggest vaccine manufacturer in the world in India, Serum Institute. But for everything, all of the vaccines you cannot. So it becomes a sort of a natural monopoly. For different other high-tech things, it is a very, very important. As we were talking and to connect with the current scenario, so vaccine availability and accessibility, it is all based on patents and intellectual property. And the way the patients or rather the countries have to spend money to make these vaccines available and accessible to their people, it depends on how much you need to pay to the company holding a patent or at least those exclusive rights. To take care of a number of these things in TRIPS agreement, there is a provision for compulsory licensing. The government can grant a license to a company in India, let's say, for example, to go ahead and make the vaccine, provided the company is capable to do that. And that is called compulsory licensing. First compulsory license in India, or rather, if I'm not wrong, that's the only one granted in 2012 to NATCO. And that was also against the German Bayer. So NATCO in Hyderabad got this compulsory license. But one thing the law says that, because remember, the basic issue is that you need to reward the inventor. So you need to give a reasonable and adequate remuneration to the patent holder. Now, this is a very tricky thing, reasonable and adequate remuneration. What is that? And there you need to understand number of things which come into action so that you can arrive at a particular number, that this is what is reasonable and adequate. Obviously, the government and the company to whom the compulsory license has been granted will come with a lower figure, and the patent holder would like it to be higher. And usually there are disputes, the matters go to the court. So in the UK, in Australia, and in other countries, there have been a number of legal battles which have been fought to get this reasonable and adequate remuneration. Now, besides patents, what you need to know is the undisclosed information also. As we were talking about earlier, the big five. So there are trade secrets and there is the know-how, the practical day-to-day work. So that you need to understand the trade secrets and know how to make it. So it's not only even patents, but you need to get to know these things also. And that has been one of the issues which have been highlighted by India and South Africa and several other countries in an application to TRIPS, where they say, please waive off the patents, particularly during this pandemic. Later on, this was amended. So first the application was made in October 2020, amended in May 2021, where several new members joined. And the idea is not only waive the patents, but please share with us trade secrets and know-how also. It hasn't been yet decided. There are, I think, 2-3 months by which it will be decided by the WTO. So thank you very much. I've tried to put on a PPT some of the ideas and thoughts, and please feel free to ask any question, your comments, remarks, anything.
So we have a slight lag in receiving questions. So meanwhile, there's one question that has already come up. That is by Ms. Chitra. She is asking, is it compulsory? Is compulsory licensing a threat to patent owners? How is it relevant to COVID times?
It is. In a sense, it is something as a deterrent for the patent holder. And how it is a deterrent is that you try to negotiate with the patent holder to get a good deal to have royalty and licensing terms. But if the patent holder is quite adamant, rigid, no, no, these are my terms, so the patent holder knows at the back of his head that there is something called compulsory licensing. And if I do not agree to certain reasonable royalty and license fee, a compulsory license may be granted. So it acts as a good deterrent in negotiation.
So we have another question for you. That is by Ms. Tripti. She's asking, according to you, how many years are appropriate for patent?
Now, it depends particularly. Now, today we are living in a world which is changing very, very fast. So for some of the things, 20 years, the time period of 20 years appears to be too long. But earlier, 20 years, okay, life was slow, so you couldn't manage. But now, for most of the patents, some of the blockbuster drugs and all, 20 years, you need that much time to recover the amount of money and then to make a reasonable profit also. But otherwise, we can experiment with 20 years for some more time because patent application approval and all, it itself takes some time.
Sir, another question, that is, sir, why the monopoly is granted for temporary period? Moreover, after the temporary monopoly period is over, can other parties come up with a similar article and have it patented?
No, no. That they can never be get a patent because there will be no novelty. It's already available.
Okay, sir. Another question. That is, sir, can government provide licenses as per its whims and fancies, or the same can be done only during unprecedented circumstances and the government has to provide reasons for it?
The law, both in TRIPS agreement and even in India, everywhere provides certain criteria. There are certain prerequisites only under these conditions. And usually, pandemic is of course highly unprecedented. For example, a company has got a patent and it's not manufacturing in ample quantity so that everyone can easily get accessibility. So there the country can issue a compulsory license. No, no, it cannot be done only at whims and fancies because it can then easily be challenged in a court of law. It has to be done for a certain reason. One of the main is that it's not available in the domestic market.
So Ms. Jyoti Jindal has written that it was a very informative session, sir. Thank you.
Thank you very much.
And we have another question, and that is, won't it be high risk that before the exhaustion of a strict period, the details of patent is put in public?
No, 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 no. The, see, the meaning of the word patent here is in quite contrast with latent. Latent, as you remember, latent heat and all, something which is hidden. So here patent means something which is in open. So it has to be in open, in public domain, so that other researchers can work on it and make things better.
Another question, sir. Sir, do we have specialized courts in our countries for patent-related disputes?
Yes, yes, yes. These are called intellectual property tribunals, appellate board, and then matters go to courts. But we have highly specialized.
Professor,
Yes, please.
Would it be possible to, is it in any country that one pegs the, duration of the patent to a certain level of profitability or super profitability, after which, you kind of relinquish the patent? Because there must be some, input output matrix when we say it is for incentivizing research and development. After that, a certain amount of profit, and beyond that, it becomes generic. Does any country have that kind of a mechanism?
See, Germany, as far as I know, has experimented with something like this, not exactly the same, but it has experimented with this, that you get a patent not for a full 20 year, but for, let's say, n number of years, much less than 20. Then it is for the patent holder. If you want to sort of further extend it, you need to go and pay a certain amount of fee to the patent office. So it depends whether your patented product is commercially viable and you are profitable. So if it is profitable, then you would like it to be patented for another, let's say, n number of years. Otherwise, you would say, okay, let it lapse and let it go to the public. So something like this is there. And a few countries are trying to experiment with. Germany, as far as I know, tries to do this.
So there is one more comment for you. That is, it was quite an enriching and informative session, sir. Thank you so much.
Thank you. Thank you very much.
Another question that has come up, that is there any way to stop evergreenery that pharma industries do?
Uh, that is typically for the patent officers to be a little more strict while they are evaluating the patent applications. And they try their best. But you see, the pharmaceutical companies, it's a multi-billion-dollar industry, and they are also getting the best of the legal services to write down all those patent applications. So it goes on as a struggle between the two. And there are several thinkers who at times say that patents do not encourage innovation, but at times impede innovation. So there are a number of articles written by well-known authors, thinkers in management and in law both, and economics. They keep on writing about these things. So to a certain extent, you can say, yes, it hampers. But in general, the basic philosophy of patents is to encourage innovation.
Thank you so much, sir. We have received a comment from Minloon. And it reads a comment rather than a question. Highly appreciate this session, sir, as it is very interesting and quite interactive with a very handy and ample instances, which makes us concentrate more. Thank you so much, sir.
My pleasure. Thank you.
Another comment for you, sir. Thank you, sir. Wonderful presentation. Can you speak on how far patents have aided in technology transfer?
How far?
How far patents have aided in technology transfer?
Oh, when you talk about technology transfer, basically it's all about patents. The lion's share is patents. So it is technology transfer is hardly anything except patents, plus, of course, the undisclosed information. So patents, whether you are assigning or licensing or giving permission for gratis, it's all about patents and patents and patents. So it's all about patents there. Anything else, Ms. Thakur?
No, sir. I think, okay, yes, I just received one more comment for you that reads, thank you, sir, from Mr. Sandeep.
Thank you. Thank you.
Thank you, sir. It was a pleasure having you here.
My pleasure. And thanks to the center for inviting me and for giving me this opportunity. I'm highly grateful to Professor Nagar, to Dr. Thakkar, and everyone else in the center. Thank you very much.
We have been joined by Dr. Carolina. Ma'am, Ranita ma'am is having some technical issue. She is unable to speak. Okay, now she's here.
Oh, no, I've connected again. Yeah.
Okay, thank you, ma'am.
Dr.
Good evening,
Alota.
everyone. Our final session of the day will be taken by Dr. Arlota. She is currently a visiting assistant professor at the University of Oklahoma College of Law, where she has taught courses on immigration law and international topics as international energy law, international commercial and investment arbitration, international business transactions, comparative law, and European Union law. Her main research interests are in the interplay between law and development and international energy law, climate governance, comparative law as applied to the judiciary, and the impact of transnational business transactions on domestic courts. Today, she will be taking a session on law and economics of climate change in the context of the Paris Agreement. Over to you, ma'am.
Thank you so much. I'm not sure my video is working properly. So I just want to confirm if you guys are able to see me and listen to me correctly.
Yes, ma'am. We're able to see you and you're absolutely audible.
Perfect. I would like to start thanking Professor Dr. Nagar for this thoughtful invitation and for being such an inspiration and with her passion and intellect with regard to law and economics. And it's such an honor and a joy to be joining you. I know it's late there in India. I'm in Brazil right now in Rio, so it's quite early. So I have a lot of responsibility in closing today's fascinating discussions. And I would like to start not only acknowledging my gratitude for this opportunity, but also talking a bit about climate change and how it is currently in own use, and it's important for all countries involved, specifically US, India, and Brazil, countries that I'm the object of my research, specifically comparative research. So I'm trying to share my PowerPoint presentation, and I kindly would like to ask you if you can actually see my screen sharing.
Yes, ma'am, we can see your screen.
Okay, perfect. So my topic today is an introduction to the law and economics of climate change. And I would like to start basically acknowledge climate change that is different than global warming. Global warming, of course, it's one symptom, one sign of climate change, which is a broader area, broader encompassing subset of problems such as the melting of the permanent frost, such as migrations and impact on species, the increasing of temperature, and so forth. So our plan for this presentation is, of course, to focus on the foundation of law and economics of climate change, a few seminal works. Then I will present a case study on cost-benefit analysis of the United States withdrawal from the Paris Agreement, and conclude, hopefully, with the importance of law and economics of climate change. I'm planning to keep my presentation within 25-30 minutes at most, so we have plenty of time to questions and discussions at the end that are, of course, I'm much looking forward to have. So this is the plan, and we start with, as I addressed earlier, with the basic concepts on law and economics, specifically when we talk about climate change. The first thing that we have to acknowledge is the concept of tragedy of the commons, meaning in absence of regulation, when we have the commons without basically the delimitation of private property, we will end up just basically with the tragedy, meaning more than the Greek sense itself, we annihilate the commons, so there won't be a commons anymore. The idea that we keep, and in the literature is always an example of pasture, we keep adding cattle, so we exhaust the resources because every individual, every owner of property wants to add as much cattle to extract, to obtain and extract as much value and resources as possible. So again, in absence of regulation, basically there's a tragedy in the sense that it's unavoidable to have such an outcome. And it's a seminal work. It was published in Science 1968, and it is still a landmark paper because it provides the framework that we need to understand climate change, in the sense that we need regulation, we need to put limitations that it does not only mean with the existence of private property itself, but also to the need of something higher, in a sense, to protect the commons from our own self-interest. And it's quite interesting when we look to Hardin's seminal work, when we read carefully about it, there is this sense that when he defines pollution as the ultimate tragedy of the commons, this notion that pollution, we keep adding, and not only extracting resources, but we keep adding materials and gases and extortions that are truly externalities, and that will ultimately lead to the default of the property itself. So again, a seminal work. When you think about climate policy itself, and we often frame as climate change as a quintessential global scale collective action problem, what does it mean? And this is something that we need to take into consideration. And of course, there's a big jump from Hardin's tragedy of the commons conceptualizations, but those are linked ideas. Specifically, when we think about climate change as being this basically global scale collective action problem, the definition of global scale collective action problem being this notion that it does not matter if a single country reduces its own pollution, its own greenhouse gas emissions, for instance, if it's just that single country and everybody else is free riding, another law and economics concept, then everybody else will still be worse off because, again, the benefits of the country that decided to engage in carbon abatement will be ultimately shared by all the countries which are polluting as business as usual scenario, as opposed to also engaging in carbon abatement measures and policies. So the incentives ultimately are skewed, meaning parties have ultimately incentives to free ride. And that is the essence when we think about all the difficulties, as we'll see later on with the Paris Agreement, in establishing a commitment, an effective commitment of all involved parties to ultimately reduce and engage in carbon abatement measures. So within this framework, I think it's quite interesting to cite, although more a political scientist than a law in economics, but he also articulates a few of law and economics concepts. When we think about the complexity of climate change, this notion, and again, the Treasure of Commons and the collective action problem are illustrative of such complexity, meaning how incentives are, once again, skewed, how they favor ultimately a race to the bottom, meaning this competition that ultimately leave parties competing, if nothing else, for the worst scenario, meaning how much they can pollute and they will have incentives to pollute more. So when you talk about international action, the main challenge, if you will, is to foster a race to the top. It's foster or provide incentives for countries to actually reduce greenhouse gas emissions significantly. And again, we've seen, and this is such a timely topic, and again, I'm so honored to be presenting today, because this November we'll have the UK is hosting the 26th Conference of the Parties that happens within the United Nations Framework Convention of Climate Change. And of course, implementing the Paris Agreement, where parties are supposed to at least negotiate Article 6 of the Paris Agreement and the behavior of, if you will, the private mechanisms of reduction of greenhouse gases, kind of like akin to market incentives. So that's forthcoming. And again, how international action can foster meaningful reductions, and that's will be the second part of this lecture when we talk about the Paris Agreement and specifically the detrimental effects of the US withdrawal from such treaty. So we need another point when it comes to international action in law and economics is this difficulty, if you will, when you think about the interplay, the relationship between international energy law and domestic energy policies, because energy policies domestically, countries want to secure economic growth. They want to secure access to energy resources. And obviously, they want them to secure growth as cheap as possible, as a lower cost as possible. When we think about international energy law or international environmental and energy law more precisely, the framework is different because countries not only have to reconcile their own interest in keep producing, meaning to securing economic growth, keeping the lights on, meaning having access to energy prices that are not expensive, if nothing else. But reconciling those with, from an international perspective on international environmental and energy law specifically, with the reductions of greenhouse gas emissions that are set in international agreements. So of course, this dynamic between domestic interest and international interest, this tension increases and ultimately consummates with higher transaction costs for all involved parties. If you think about politicians, how they will frame the domestic agenda to secure a meaningful reduction internationally, and again, domestic policies having to reflect such a reduction it is a challenge, and it's something that the methodology, and that's the third bullet point, the methodology of law and economics can help, whether it's from behavior economics, whether it is from approaching countries in a negotiation table scenario from a perspective based on essentially this analysis that everybody would be better off if reductions occur, meaningful reductions occur. So again, this collective action problem, again, the tragedy of the commons, being formative of the outcome that we don't want to pursue. So I have a few slides more, I would say, I cannot use the word entertaining, but I think they are illustrative of a higher point that it's, again, motivated or illustrated, if you will, by law and economics. So the first one is the notion that global average temperature is increasing, and depending on the data, the scientific center that we use, there will be distinctions that we see the valuations, but basically pretty clear that it's increasing, and it's increasing fast, and it's man-made, meaning mankind is causing it. This is another graphic illustrative of such variation, and of course we see the more you are towards the orange and red scope, the worse you are. So we see the temperatures increase more than 7 degrees Celsius if you were between this increase that already had occurred in 1981 to 2010 in comparison to 2020, so just last year. This slide, I think it's particularly illustrative of what happens in the absence of international action. So basically, carbon emissions keep going, specifically here, carbon dioxide, which is one of the main greenhouse gases, they keep increasing and increasing only. So of course, when they don't increase, is because we didn't increase, is because we had the Spanish flu or the Great Depression or world wars or the oil crisis, the first 1972, 73, and then 79. Of course, the collapse of the former Soviet Union also led to a slight reduction with regard to carbon dioxide emissions, but again, just because those countries were facing very political challenges, so that obviously had an impact on their production or industrial production. Nonetheless, it was very mild, and then it always recovers, it always kicks back and recoup very fast. The forecast for 2020 with the pandemic was, of course, to have a significant reduction. But nowadays, and this is not super updated, but I don't have like the full updated scale of the data in terms of reduction, specifically because, as we mentioned earlier, the pollution has already restarted, and again, quite fast. I really think this slide is interesting because it tells us a bit about how difficult it is illustrative of the difficulties involved with regard to climate goals, with regard to implementing the goals established by the United Nations, because as we've seen earlier on today, because of this collective action problem. So we started with the United Nations Framework Convention on Climate Change, dating back 1992. This broad, as a framework convention, this very broad mandate to reduce emissions, early anthropogenic emissions. Then we have the Kyoto Protocol, 1997, with clear targets with regard to overall emissions, at least 5% below 1990 levels. Meaning, well, now we have a percentage. Now we have this joint effort of countries, and of course, and related to the second part of today's lecture, the fact that, presentation technically speaking, not a lecture, the fact that the United States has not signed. I mean, initially the Clinton administration committed to, but the Senate, the US Senate, has never ratified the Kyoto Protocol. So again, because it was this change of government for the Bush administration, and in defense of the Bush administration, the Senate itself, the U.S. Senate issued a joint declaration saying it was not in the best interest of the United States to join the Kyoto Protocol. A case, once again, illustrative of such a tension, illustrative of the challenges involved with climate policy, specifically collective action problem. Then we have in 2009, the Copenhagen Accord that sets the urgency, set the record clear, set the record straight, as soon as possible, the reduction to 2 degrees Celsius. And for the first time, we have that quite clear. So, and of course, 2015, we have the Paris Agreement, this major achievement, far from ideal, nonetheless, tries to address, to reconcile this collective action problem, basically putting every country, doesn't matter if developing country as Brazil, doesn't matter if the developed ED at the end countries as European countries in, I would say continental European countries, and as, of course, the US, as we see later on. Paris Agreement 2015, quite clear when it comes to achievement, as far as soon as possible, emissions equal removals in the second half of the century, keep temperatures well below 2 degrees Celsius, and by ultimately countries, islands, small island countries, the pursuit of efforts to limit the emissions, and of course, increase of temperature to 1.5 degrees Celsius. So again, very interesting. I'm mindful of the word evolution, but I would say very interesting developments, if you will. So we have international action, we have the Paris Agreement, the Article 2 target, pretty much saying what I have already summarized in this earlier topic. Is it, and at this point you would tell me, but Carolina, is it to say that the Paris Agreement is perfect? Of course not, it's far from perfect. The national determined contributions, which are voluntarily determined by every single country, have been criticized as being very less than ideal and actually not as ambitious as we need. And we see the criticism, and of course you have the Prime Minister Modi, and you have, starting from your right to left, former Prime Minister of the UK, David Cameron, then Obama, former President of the US, Obama, then President of China, and then, of course, former President of France, Hollande. So all the leaders, of course, are on board and were on board for Paris Agreement, but the cartoon is illustrative, and I don't, of course, mean ever any disrespect, but I think it's important criticism that to be shared in the literature, specifically international environmental and energy law. It was very clear that despite the best efforts in terms of collaborations, in terms of setting targets with the national determined contributions, meaning this bottom-up approach, those national determined contributions are far from sufficient for having a meaningful impact. I really want to just share a bit of my own research using law and economics, and I'm always happy to chat about it later. And again, Professor Nagara, always an inspiration. So now we switch to the second part of this presentation, which is basically an article that I wrote and was published last year at the University of Pennsylvania Journal of International Law, and basically focus on cost-benefit analysis. So bear with me, it is a methodology that looks for not only law and economics methodology, but it's specifically methodology that is aiming at saying, okay, so why the US ultimately decided to withdraw from the Paris Agreement? Was this irrational behavior? Meaning, does the costs outweigh the benefits, whether just for the US, whether for other nations, so measured globally? And we know there has been a significant backlash, even for domestically, so people within the own Trump administration, members that were politically appointed by the Trump administration, and of course internationally, and that's where you have President Macron from France, and Angela Merkel, Chancellor from Germany. So once again, when you think about substantive account, like how can we measure the costs and the benefits to compare and ultimately say, okay, the benefits outweighs the cost, so we need to basically withdraw from the Paris Agreement. The US needs to withdraw, or the vice versa, the other way around. The US departure from the Paris Agreement will be far tragic, not only for the US, but for the world itself. So that's what I'm basically aiming when I mention substantive account. However, there are challenges involved, like how one measure, how one define cost, what is a cost, what is a benefit, in advance, or should it be defined with regard to the interests that are to be protected by such a policy, specifically here, the analysis of the withdrawal, and also how, specifically because of the Trump administration, remove from the calculus of the social cost of carbon, the global impact, then we were pretty much in the dark in terms of comparison, because such social costs were only measured domestically as opposed to globally, which is of course the majority of the literature. So, and also with regard to challenges involved, we have to rely on economic predictions of, including the state of the economy, and of course the Trump engaged in an economic trade war with China. So segments of the economy were reduced, therefore we're not polluting as much. On the other way around, the economy was booming in different fronts, therefore increasing the pollution, meaning the emission of greenhouse gases. So something that I want to call your attention on, we'll see this notion and incentives for parties to basically switch from coal to natural gas. And we say that very lightly and very, I'm going to say efficiently, like, oh, this is much, much better. But let's take a look at the numbers, and the coal bituminous, which is the second coal that you see from top bottom, is the most used type of coal in the US, and it's quite polluting. So 205, when you think about burning from carbon dioxide emissions. And in comparison to the natural gas, of course, natural gas produces roughly half of it, but it is still a lot. So half of a lot, is this still a lot? Is this still significant? So when the US considers climate policies, it ought to consider, because the US is the historic record polluter with regard to greenhouse gases, the record emitter, they have to consider their own domestic energy policies specifically. Even the transition for natural gas is problematic, hence extra incentives for renewables in general. So let's look at the numbers. So Paris Agreement could avoid between 70 and almost 2,000 heat-related deaths only. And as this summer is showing, the US, those numbers might not be as updated. More research needs to be done. But again, those we're talking about only death related for basically heat-related deaths. So quite interesting. We're not talking about those who their health are suffering an impact, for instance, for because of pollution, because they have asthma, because they have basically a respiratory condition that is aggravated ultimately by pollution. Quite interesting for the law and economics folks, meaning all of you, I hope. In this, it's the climate change impact on US GDP, specifically between 1.5 to 2%. That is a lot. And we'll see, I have another slide with the ultimately the national disasters, the billion disasters industry that is happening in the US just last year. So quite interesting. But even more problematic, we have GDP decreasing by 10% from 2070 to almost 2099. Those are, of course, estimates right now, but quite interesting. This was the slide that I was referring earlier on, the US $20 billion weather and climate disasters. They were many, they were significant, and of course, they all caused more than $1 billion. And again, very costly from the economy. So when you think about domestic and costs and benefits of the US withdrawal from the Paris Agreement, we're pretty certain, even though we don't have a specific target number, we can confidently say that basically the cost of the US withdrawal from the Paris Agreement domestically outrages the benefits that the country would have, including transitioning to cleaner energy. That's the last question in the PowerPoint. More problematic when you think about climate justice, when you think about inclusion, and when you think about efficiency, of course. We think basically, I'm not discussing Pareto here, but we see this very Calder-Hicks approach, basically just compensation being theoretically required, but not in practice. And why is this problematic? Because we know for sure, and we can tell, that certain segments of the population will suffer more from the impact, the adverse effects of climate change than others, specifically minorities, racial minorities, foreigners, indigenous populations, because they rely more on natural resources as opposed to more industrialized food. On top of that, the decision to withdraw from the Paris Agreement was particularly problematic because it could ultimately progressive momentum in terms of energy transition, and also in terms of federal action, in terms of, because the US is a federal system where each state has has such a strong say on their own policies, there is a perennial need of a strong federal policy to help to assist with that, basically providing uniformity and also incentives for parties here, meaning the federal entities, the states that are part of the US Federation, to change the policy to reduce that greenhouse gas emissions. This is just a ranking. I know it's a bit dark and hard to read, but I think it's quite interesting because it basically shows the US in the aftermath of the country's withdrawal from the Paris Agreement became ranked at number 40th when it comes to innovation and climate policies among 76 countries. So basically, if you think about the US, if you think about half being 35, the US is far below the average country. And it's quite interesting because they have developed countries and developing countries. They even have Brazil, Uruguay, and the US was ranked lower. So it's pretty much a wake-up call that, of course, the Biden administration is very sensitive and very interested in reverse. So what is the weight of the US withdrawal? Can we price, can we quantify, can we have a price target? Not completely, but we can isolate and we confidently can say that it jeopardized US interests, whether it comes from economic growth, that it's coming to fostering energy transition, or health and avoiding heat-related deaths as much. We can also confidently say, and we don't have a price tag on that, that it jeopardized climate governance, meaning specifically when it comes to the Paris Agreement, for the parties involved, meaning except for Europe, most countries, Australia, Brazil, they all, once the US was out of the Paris Agreement, became more reluctant in finding ways to either fulfill the original commitment as signed in the nationally determined contributions, or as expected in the Paris Agreement, every 5 years, every country should issue more ambitious targets when it comes to nationally determined contributions. That momentum was lost. And Brazil is an example, Australia another example. So we see that reiterating worse example scenarios. Another point that calls the US responsibility, and this is another slide, but I really think it's interesting because it completely shows us that US historic emissions and leading historic emissions, even if we are comparing with China now, it gives us a perspective. We do have India with 3%, but again, 3% versus 25% of the US, 22% of the EU is quite interesting. And of course, that won't be, those numbers are not for cumulative, global cumulative emissions. When you think about North America in general, US and Canada, 29%, in Europe, 33%, and you have all the other continents. And I think it just adds perspective in calling responsibilities and considerations, and of course, economic considerations, meaning what is the value of the US, withdrawal for the US itself, but also for the world. Also, reputation issue, the US withdrawal basically jeopardized US reputation in terms of climate policies, or in terms of US leadership in the world, around the world. So beyond the impact of the domestic points that we've discussed, there is, of course, a significant damage to climate, significant damage to climate action that now the Biden administration is trying to recover, basically to mitigate the damage, and then to become a leader, to become a key player, which remains to be seen. Contributions to the Green Climate Fund, the US basically under the Trump administration stopped contributing, which was a major problem to the extent that countries rely and need for such contribution, either to help developing countries specifically to help the transition, to implement their energy transition, or to basically have access to information and data. So the consequences of the United States free riding approach are also paramount, because the country became actually has now a reputation of a country that does not commit to the environment, to environmental policies, environmental treaties, and of course it left a leadership vacuum. So conclusion, it's bad to have policies formulated on the basis of hopes, and policies that are very targeted to electoral bases, specifically with favoring coal power plants based on coal, as opposed to renewable energies or cleaner, greener energies, as we've discussed earlier. The world is the first 10 years of the Paris Agreement are, of course, significant. It is our window of opportunity to act together, and this has been a major challenge because of the US withdrawal. I'm very mindful of causation there, but here we have a clear cause. And the importance of law and economics of climate change, because it basically helps not only domestic policy, as we've just seen with the cost-benefit analysis approach, but also it helps countries to see the costs and the benefits. It helps countries to be on the same page. It fosters the use of scientific method, as opposed to hoax policies based on hoax, or policies that are more in political oriented front, or populist front, if you will, as opposed to a rational front, not only domestically, but specifically globally. So those were my main topics that I want to discuss, and I think we have still plenty of time for questions and more questions and comments and feedback that I am very much looking forward, as I established earlier on, to hear from you.
Thank you so much, ma'am. Ma'am, there's a slight lag in our chat box, so maybe we'll be receiving the questions in a bit. I'd be happy to put it across to you.
Thank you.
Okay, ma'am, I got a question. It is from Mr. Sandeep. He's asking how far military forces are contributing to climate change, whether they are made accountable for them for this under the Paris Accord.
Yes, this is a terrific question. I'm not familiar specifically about um, how military forces specifically, I don't have a number for that, how much they are contributing to it. But I do want to say that some countries, for instance, the US, are considering the impact of climate change as a threat, a military threat, which is interesting from two perspectives, but because their military personnel, when abroad, it's subject to, you know, flooding or increased temperature that will perhaps impact the performance of their own machinery, military machinery and so forth, and equipment, better saying. Or if it is more into the leadership issue, meaning that whether refugees or the US, because there will be an increase in military conflicts because of food production or because of flooding or because ultimately with climate change, not global warming, but specifically climate change, there will be a disruption of national frontiers, national limitations, geographical limitations. It is expected that the military forces will kick in, or either to provide protection or to engage in expansion of territories or take advantage of whatever that might be, whether it comes from protection or to, how should I say, to basically secure their own geographical location. So there is an important link, and there is also a lot of research that needs to be done in terms of quantifying the impact. So I'm not familiar with any paper on that. I hope I have answered.
Ma'am, there's another question for you that reads, what steps do you suggest that India, being a developing country, should undertake to reduce CO2 emissions?
This is also an excellent question, and I want
And
to start.
sorry to interrupt you, ma'am, but for the previous question, Mr. Sandeep has thanked you and he says, yes, ma'am, you have answered his question.
Good. It's always good, and I thank his gracious confirmation. I'm not sure I was there yet, but I appreciate the feedback. Thank you. And as far as the question about what India as a in this current state of development, what India can do, should do. So in the thoughtful introduction to this lecture, as you know, I teach comparative law, and I try to not at least consciously engage in the first, I should say, cardinal mistake of comparative law, which is basically to engage. Here it's not comparison, but as a foreigner, as Brazilian, I cannot. I'm not familiar enough with the current India complexity when it comes to domestic energy and environmental policies. Of course, I've read a lot, and I haven't discussed India specifically. I've been discussing and focus on Brazil and the US and the global impact in general. But what I realized in my research focus on the United States and Brazil, and those are completely different countries. The US, as we've seen, with a major responsibility, at least for being the historic record polluter, versus Brazil versus India, whose emissions are not historically significant. So that brings I think it's a significant point to comparison. But I think all countries, India, Brazil, Australia, US, have an interest now. And that's where, again, law and economics helps us, and have a comparative advantage in switching as quick as possible to a green economy for two main factors. Because first, the sooner you pollute, you switch to greener energy, you will be polluting less. So basically, the population around you, so in India, in Brazil, whoever the country, specifically the question was about India. So the population, the Indian population will be benefiting from greenhouse gas reductions immediately. People will breathe better, they will have a cleaner air, and also economically, as much as important as it can be, because they will have not only transition from coal, but also they would be in the forefront of renewables. They will also be using, not only benefiting from the health benefits and lives that were saved by not having death related to climate disasters or pollution in general, but also from this, when we mention comparative advantage, is this notion that if others are not doing but you are doing, you will be better off the sooner you transition to renewables, just because again you will be collecting the benefits, if you will, of a greener air, greener society, but also it is basically more efficient to pursue renewables. Nowadays, it's not as expensive as it was 5 years ago, 10 years ago. So this is the time we are living, the historical time, like 2021. The technology became accessible. There are pretty much no excuse to not engage. Of course, it is still expensive, but the question becomes and again, this is where cost and benefit analysis can help every single country to determine the policy and to determine the transition to such a greener society, which will be greener society in general, but of course, greener production of energy, sources of energy on that note. So I hope that I have humbly answered more in a general note about the advantages of every single country, Brazil, India, Australia, US, to switch as quick as possible to renewables, to greener economy, to make this transition. And again, it is something that it's needed, and it's at the advantage of everybody else, so collective action problem again, all the countries, but also to the country that starts doing this at first and that the fastest, because they will be, there is this notion in the literature nowadays that pollution is a faulty product, right? So if you have a product that causes damage, so if you have a toy and the toy basically it's able to harm the child, this is it's a tort. It is basically a toy that has to be removed from the market because it causes damage, because it causes harm. So nowadays we see the pollution being a tort, not only from a domestic perspective, from a global perspective as well. So I think that's also a good approach. I hope I have answered again. Perhaps with some more details than the previous questions, but.
Thank you, ma'am. We have one more question, and that reads, since we don't have genuine sharing of green technologies by the developed world, how can we hope to tackle climate change?
Yes, another fantastic question. There is actually, and this is something that the Paris Agreement, within the framework of the United Nations Framework Convention on Climate Change, tries to push for, not only when we have the Climate Green Fund, not only for the sharing of money, meaning monetary resources, but also for the transfer of technology. And there is nowadays this acknowledgement in the global world, like all countries acknowledge that without any measure of transfer of technology or sharing technology for that effect, we won't have this transition to a greener economy in time. So, of course, there are a lot of incentives for private parties specifically to not share their technology. But if governments started sharing their technology, the resources, as they were doing, for instance, with the pandemic, where we have like sharing of, numbers of death or causal links in research, private and public institutions engage in such a sharing, then we need to start thinking climate change as a pandemic, as something that needs urgent action. But the problem is we don't, because of discount rating, because of our own bias when it comes to evaluating problems. So of course, we see the pandemic, we see the COVID-19. We know if you don't, if you're not put in, in oxygen, you die. So that's pretty, immediate. But most of us still see climate change as something not as immediate or as not being in need of urgent action as it is actually. So again, something that needs to be worked out and fast, because just black letter law as it is in the Paris Agreement, for instance, it won't be enough to actually help us at this point. We need more than just, a will or protocol of intentions. We need, to actually have such transfer of technology to secure that specifically developing nations make this transition as fast as possible.
Radhika has very kindly thanked you for your session and for your answer, ma'am. And we have one more question for you. That is by Mr. Ronak Jain. That reads, ma'am, how relevant do you think the upcoming COP in Glasgow is going to be, seeing the IPCC report on climate change that came out lately?
Yes, another fascinating question. I am very excited. I mean, we have the British Prime Minister Boris Johnson, the UK, technically speaking, Prime Minister Boris Johnson, saying that it was devastating. We do hope that, and the Biden administration and Canada have been reacting with what they call, I think the correct quote from Boris Johnson was that it was sobering. And I mean, they're releasing portions of it, but I think the expectation is that by November, more data would have been released, and that will put pressure, in my humble opinion, on all the involved parties, developing world, developed world, to actually implement Article 6, so the market-based mechanisms, and also what we have with the Kyoto Protocol with regard to the transfer of pollution on that. So I think that's law and economics operating at the quote unquote best, in the sense that suppose they can actually implement that provision. And also, which of course we know it's controversial because there is a significant portion of the literature that says that we shouldn't be polluting at all at this point, because the world, the level of saturation, the earth doesn't basically cannot take it anymore, which is something that of course I agree, but in practice, it's very difficult for parties involved, specifically because of economic interests involved. So I think it has everything to be a sea change, from an inertia standpoint, from business as usual, from we all know from law and economics, behavior economics, that human beings are reluctant to change, but we need to change now. And the good news perhaps is that we have potential instruments and we have potential international agreements, specifically the Paris Agreement, that comes within the framework of the United Nations Framework Convention on Climate Change. So there is already a skeleton of action. There is a lot of, we have the foundations for meaningful action. But again, although I'm willing to be optimistic, although I think this the UN report adds momentum and will be, it is a game changer for the countries involved, that the countries that will be in Glasgow that are members of the Paris Agreement. It's always the question that what will be done. So we need diplomatic efforts, we need international leadership. So it's good on that front specifically that the United States is back to the Paris Agreement, so back in the game as we move forward. But it is very difficult, my crystal ball, it's very difficult to make predictions. But if history is any indicator, is that there are incentives for parties to come to an agreement of meaningful reduction, not only in terms of national determined contributions, but also with regard to implementation of Article 6 of the Paris Agreement, and also with regard to peer pressure among countries. But there will always be a sense that we are behind already. So I'm Brazilian, I'm always optimistic, but I think we have to be careful because chances are it won't be meaningful enough. But remains to be seen, and perhaps we can have another session on that after, after November and see how it goes. I will be happy to, but please stay tuned. And it's something that it's on the daily news. It's something that we are all affected. So thank you all.
Thank you so much for your answer, ma'am. I don't see any more questions, but a lot of people have really kindly thanked you for your session.
Thank you. They are very generous, for sure.
So one just came up, that is by Ronak Jain, and he has thanked you for a wonderful session. And Rajneesh Tripathi writes, nice session. So I have my whole chat box filled with this.
Shubhi, could you also convey my very, very warm thanks to Dr. Alota?
Indeed, ma'am, indeed.
Thank you, Dr. Alota. Thank you so much for your time.
Thank
we look
you.
forward to more sessions.
That's very kind of you, but my gratitude and my joy in joining you in such a distinguished event, such an honor. Count on me, and I was, I'm beyond grateful not only for this opportunity, but for having I would say the distinguished opportunity to hear from your fascinating audience. And those were wonderful questions that really, as they say in the US, gave me food for thought. So I'm beyond grateful again. Thank you.
Thank you so much, ma'am. It was a pleasure having you today.
My pleasure.
Shubhi, are we concluding for the day?
Yes, ma'am. I think we're done for the day then. Pratyusha, can you please conclude?
I was just doing that. We have now concluded with day 4 of the workshop. We will see you tomorrow again for the final day of the workshop on research in law and economics. Good evening, and thank you for attending the session.
Thank you, Pratyusha. Thank you, Shubhi. Thank you, participants. See you tomorrow.
Thank you, ma'am. Thank you.
Thank you, ma'am.